We're only gonna be going over the actual contract. We're not gonna be going over any of the addendum or anything like that. We will, if you have questions with addendums afterward, we will address those. The biggest thing is, other than lead generating is your first priority. Without leads, you're not writing the contract. Your next priority is knowing what's in the contract and being able to tell your buyer and seller what's in the contract and how to write it up. Primarily focusing on the Maryland Realtors contract. Okay. So if you're licensed in multiple states, the reason you have copies of the other states' contracts is because you're going to take them home. You're going to do the same thing with them that you're going to do with the Maryland contract. You're going to read it. That's an absolute must. That is your responsibility as an agent to know what goes in this contract. The only thing that you're supposed to do are fill in the blanks. Okay? There's a lot of different ways that you get the information to fill in the blanks. Now, in saying that, you should know everything that's in this contract. Because everything that's in this contract is going to have an addendum to it or some other form that's going to need to be used. Part of that's going to be a buyer agency form, a listing agreement, as is addendums, inspections addendums, legislative addendums, a whole gambit of things. And everything that's in this contract based off of what's in the MLS, because all the information is gathered through the MLS and from your buyer's lender. And for those of you that have questions about the financial addendums, whether it be conventional, USDA, VA, FHA, your lender should be providing you with information that needs to be put on those addendums. If they don't provide that to you, you need to call the lender. Typically, they'll send a pre-approval letter, and it should be on the pre-approval letter. So, in reading this contract, I'm going to pick on people today, and we're going to go through it. And the first person I'm going to pick on, my favorite Marine. Is to John. So what I would like for you to read is what's above, everything above date of offer.
This is a legally binding contract. If not understood, seek competent legal advice. This form is designed and intended for the sale and purchase of improved single-family residential real estate located in Maryland only. Time is of the essence. Time is of the essence of this contract. The failure of a seller or buyer to perform any act as provided in this contract by prescribed date or within the prescribed time period shall be default under the contract and the non-defaulting party. Upon written notice to the defaulting party may declare this contract null and void and of no further legal force in effect. In such event, all deposits shall be dispersed in accordance with the paragraph 20 of this contract.
Okay. Does everybody understand what that says?
Pretty much.
Okay. Does anybody have any questions about what that says? Go ahead.
So I want to see if this
I'm understanding it correctly, when we moved to Hagerstown and we sold our house in Rockville, there was an inspection. And there were things that had to be done. I knew we had like 5 days or something. And so is that like what they're alluding to?
They're alluding to all timeframes in this contract, because there's timeframes in this contract for all items in a contract of sale.
So if we hadn't done it within the 5 days or whatever, it would have been null and void.
You would have been in default, and the opposing party could declare the contract null and void. Okay, so if they can declare the contract null and void, what does that mean?
We don't have a sale. And the money goes back. The money goes back to.
Where's the money go? We don't know yet, do we? It depends on what's in paragraph 20 and the reasoning for the contract being declared null and void. What's one of the biggest, most important things in what he read?
Time to sell the assets.
That's one. What's the other one?
Don't understand.
Exactly. Yes, you should tell your person that you're writing the contract with, if you don't understand anything in here, you should seek competent legal advice. If their question is, should I have a lawyer? My response is always, well, if you have to ask if you need a lawyer, you probably have a lawyer. Is it? The full 12?
11/9/80/58.
Yes. Are they gonna send it?
She's faxing it over, but it may not get to us till tomorrow or whatever, but it's coming.
Good. That's gonna be good for you.
You excited before.
Did somebody, did we get that on tape? That's awesome.
Yeah, you are recording this.
That's awesome.
Am I on there? I'm not on there.
Oh, man.
Okay. So. Shelley.
Yes.
Starting with number 1, read through to number 5.
Date of offer. Do I gotta explain anything?
Yep.
Okay. Put the date that you're submitting this offer, filling it out. Seller. Who is selling the home under the disclosure documents or public records, put the seller's name in there. Who your buyers are for number 3. Number 4, property. Property is known as, you put the address.
We'll read the whole thing.
Seller does sell to buyer and buyer does purchase from seller. All of the following describe property, herein property, known as blank, located in, put your city, county, Maryland, zip code, together with the improvements thereon and all rights, and I can't say that word.
Appurtenances.
Appurtenances thereto belonging. Number 5, estate. The property is being conveyed in fee simple or is subject to an annual ground rent now existing in the amount of blank dollars payable semi-annually as now or to be recorded among the land records of blank city or county in Maryland.
Okay. So number 1, you always start with the date that you're going to be writing this offer. If you're writing the offer today, you're going to put today's date. Okay. The seller, it will never be owner of record. No matter what.
Say that again.
It will never be owner of record.
Always has to be their actual name.
It always has to be the actual name of the person that's selling or owns the property. The buyer's name. Yes, the buyer's name needs to be filled in.
And if it's a LLC or corporation.
If it's going to be an LLC, then you should put it into the LLC's name. If it's a corporation, then the corporation's name. At the same time, if you're going to be doing something with an LLC or a corporation, you need to make sure that the person that is signing the documents has the authorization to sign the documents. So you will need articles of corporation. I was getting there. For the LLC or for the corporation. If it's an S corp, whatever the case may be. And if there's more than one signatory, you're gonna need all signatories. Yes,
What if it's a trust?
then it's going to be in the name of the trust. And the trust, you're gonna need the documentation that shows that the person signing the document is the legal signer for the trust. Same thing with a power of attorney. And sometimes different closing companies require different things. The way it should be done is it's always in the seller's name. So if the power of attorney is signing this, it is still in the seller's name. So whatever's on the deed, that's the seller. And the person that's going to sign it is the power of attorney. It will be signed, whatever the seller's name is, by that person, POA. No. Take a contract, the Maryland one.
Yeah,
This
that's.
one here?
Yep.
What about this one?
Nope,
Okay.
Watch the wire, watch the wire.
watch the wire.
Okay.
You almost tripped.
Now, you know, I wouldn't be surprised.
Lenny, I do have a question.
Go ahead.
For the, date of offer, is it the date we're writing the offer or the day we're submitting the
The
offer?
date you're writing the offer.
So it doesn't matter if we're submitted, but
No, because what's gonna happen is you guys are gonna counter back and forth, and on the very last page, once it's accepted, you're gonna put the date of acceptance, because the date of acceptance and the date that you write the offer are two different things.
Yeah.
Okay,
you're right.
property, the seller does sell to the buyer, and the buyer purchases from the seller all the following described property hereinafter known as, and you're going to put the property address. Now, in Pennsylvania and West Virginia, for those of you licensed in Pennsylvania and West Virginia. That paragraph, you'll note, also states that you have to put in the deed references and items from the tax record. You can find that in the tax records online through Bright. The estate,
Oh, can I just say that? I think the Pennsylvania one might not be.
we're not going into,
No, it says commercial real estate.
that's okay.
Oh, is it right?
Yeah, for right now, that's okay. We're not going into the Pennsylvania.
All right.
We're only focusing on Maryland. That way nobody gets confused,
Okay.
okay? The estate in Washington County, Frederick County, Allegheny County, Garrett County, you're not going to find that the properties are subject to an annual ground rent. Okay? What you are gonna find is if you get down into Baltimore and Howard County, there may be properties there that are subject to an annual ground rent. Now, in this location around here, there's a lot of people that know about a couple of the mobile home parks, and they charge lot rent. That is where you'll put in here the lot rent for that property. West Virginia, you won't be doing anything like that because that would be a mobile home and you have to have a car salesman license to do so. Pennsylvania, you can do it. And theirs would be the same thing, and they have their own contract for it, okay? The purchase price. This is where you're going to spell out the purchase amount in writing. And it will be whatever that purchase price is, whatever they're gonna offer. And then you'll use the numerical version in the parentheses. Every time you see that in the Maryland contract and on the Maryland addendum, you're always going to spell it out and then put the numerical version of it. Payment in terms. The payment of the purchase price shall be made by the buyer as follows. An initial deposit by way of blank in the amount of blank at the time of this offer. What would go in those blanks?
It's conditional deposit. Is that wrong?
Earnest money deposit.
That's right. That's where the earnest money deposit is going to go if you're providing it at the time of the offer. What if you're not providing it at the time of the offer?
I thought you had to.
No, Maryland does not require a deposit at all. It's just that when the listing agent gets it, and there's no deposit, they may say, well, this guy didn't even want to put a deposit. Is he really serious? You do not have to place a deposit.
I have a question. When we are depositing for earnest, or whatever you want to call it, what are we putting in that blank? In addition, a deposit by way of
ACH.
ACH is the,
That's the proper term for it,
okay.
for
What is it
earnest.
called?
Mhm.
What does
Because
it
we do
say?
not accept checks. So we'll get this one out of the way real quick.
So we just say ACH, no earnest money deposit. Just ACH.
It would be an ACH,
Automatic clearinghouse.
okay?
Thank you for that.
Sure, I got you.
And that would be the deposit by way of ACH. And you can put in parentheses, earnest, and the amount. Now, what I recommend that you do, so that you're not writing up a whole bunch of different offers for people, is that you skip this line and you go to the next line that says an additional deposit by way of ACH, earnest, in the amount of, and whatever that amount is, to be paid. And what I always write in here is within 48 hours of contract acceptance.
I don't want to be, but I am a newbie, so
That's okay.
we don't take checks.
No,
So what is, I mean, what is ACH? What is?
it's,
It stands for automated clearinghouse.
yeah,
It's basically
it's,
just
it's an electronic
transfer.
transfer from their bank account to ours. Okay,
They do it online.
they do it online.
They do it online.
And the nice thing is it prevents checks from bouncing. If you are working with a buyer and that check bounces, who's responsible for that bounced check?
You think?
You think? No, ma'am. According to the Real Estate Commission, you are.
Why?
Because you did not do your due diligence in making sure that they had funds available for that check to
So-
clear.
Can I just, I'm sorry, so we have to, our potential buyers. we
You have to take it up with the real estate commission.
We have to ask them to look at the account.
Whatever the case may be, you need to verify that they do have the funds available.
But that wouldn't happen with the ACH, right?
Correct. ACH is gonna come directly out.
Also prevents commingling.
Well, not just that, well, it doesn't really prevent commingling per se, but what it will also do is it will prevent somebody from being able to get a copy of that check that was emailed to somebody and getting their routing number and their bank account number and getting into their bank account.
When did they stop taking checks?
We stopped taking checks, what, a year ago?
It was a year or two.
Okay, because I remember we did, it was 5 years ago when we did our. house
Well,
visit here.
Every office is different. This is our policy.
But
Okay.
I'm sorry, Lenny. I haven't done much business. with-
Take it up with the real estate commission.
No. But but if I give you an offer for somebody, so I don't know, what do I give you? Then in order for the earnest money deposit?
You'll get a receipt when they do that deposit.
Yes, but how do you know how to do such a deposit? Just by my words telling you, Lenny?
No, they're gonna get a link, they're gonna deposit the money into our account, we'll be notified that the deposit's been done, and you'll receive a receipt, and that receipt needs to be submitted.
And that service costs 15.
That service costs $15 to the person that's transferring the funds. And typically what I find is nobody really has a problem with it.
What about if someone to give you check?
If they wanna give you a check, then it's gonna need,
Cash.
if they wanna give you a check, it's going to have to be made out to the closing company. And then you're gonna need a separate addendum for the escrow agreement.
What about cash?
No, you can't take cash.
And it's.
Oh,
Big ones.
When do you tell them this? You tell them when you do in the contract that.
Well, you should have these discussions with your buyers when you first meet on how you do things. That's the purpose of a buyer's consult, okay? Now, it states under number 7 that all deposits will be held in escrow by. If they're gonna do earnest through us, it will be by Keller Williams Premier Realty. That's who will hold it. If they're gonna put it into escrow at a title company, you're gonna put the title company, then you're gonna have to include the escrow agreement. If they're gonna hold it at the other brokerage, then you will put the other brokerage's name in here. So there's more than one way to get an earnest money deposit from somebody. But if we are holding it as Keller Williams, it will be by earnest and earnest only. Everybody got that one?
Title company requested that, it stays with us or?
The title company actually doesn't request the EMD until it closes. If the person that's writing it wants it to be done with the title company, then that's what they'll have. If the other agency requests that it be held at a title company, then they'll put that usually in the listing. But then you have to have the escrow agreement that a title company is holding it. Why do you have to have that escrow agreement?
And where did you find the escrow agreement?
Because
The escrow agreement is in the Maryland document.
From us over to the.
No, actually, no. The reason you have to do the earnest money deposit when you're using a title company is because title companies do not have to abide by Maryland brokerage law to release that deposit. They can keep the deposit for themselves. They can take the deposit and give it to the buyer. They can take the deposit and give it to the seller. They can do whatever they want with it. So the escrow agreement spells out that they have to act as a brokerage and can only release the deposit upon mutual release by the buyer and seller. Any questions on that?
Then we ask you when you write the contract.
Huh?
I said, I will come to you.
Won't be coming to me,
Not for 6 weeks.
not for 6 weeks.
I only.
So what happens with this deposit? When you place the deposit on a property, what happens with that deposit?
It has to go to a non-interest bearing.
It goes into a non-interest bearing account, but what else happens with that deposit? When the
Goes
tr-
to the seller at closing.
doesn't go to the seller,
Or goes back to the
But they
buyer.
could apply
It's
to.
it gets applied to the buyer's purchase price, so it reduces the buyer's purchase price. It will never go to the seller
Unless it's just.
unless the seller, the buyer and seller have agreed to release the deposit to the seller. Still have to have mutual release.
One also. I have a question. Why are we putting additional deposit within 48 hours?
Because are you going to be putting an ACH deposit at the time of the offer?
Oh, okay.
I mean, you can, but what happens if the offer doesn't get accepted?
So you leave that blank.
Yes.
And
Actually, you really don't leave things blank. You should do what?
And then.
and it-
Not applicable. Nothing in a contract should ever be left blank. The rest of the amount that's going to be paid by the buyer is going to be in the form of a cashier's check at closing, or wire, or both. It's always in a non-interest bearing account. If somebody is buying a $1 million property and they want to have the earnest money held in an interest bearing account, we will do that because maybe the earnest money is $100,000. We will do that, but that buyer is responsible for the fees charged for that account. Okay? Any questions with that? Elsa, read the next one, number 8.
Number 8, date of settlement.
What else?
That's it.
No,
Oh, or soon, yeah, a date of settlement, whatever date, or sooner if agreed to in writing by the parties.
where do we get that date from?
That's the lender.
Correct. The lender. Why do we get it from the lender? Why can't we just put an arbitrary date in there?
They control the money, make it happen.
Or if the lender says we can get it done in 20 days?
Then you should try to go for it. Like you still put more because crap happens.
Yeah.
When it's not. Well,
Yeah, I agree, yes.
If it's cash, then you talk with the title company to find out how soon they can get the title work done.
Yeah.
Because that's going to depend on how fast they can get that done.
Yeah.
So
Okay.
that's taken into account by the lender or the date they're gonna sign for settlement. It's gonna be having all the title process and everything also.
Yeah, the most lenders will tell you they can usually get things closed in 30 days. So when they tell me they can get it closed in 30 days, I'll put 45 days. If they tell me they can get it closed in 45 days, I'll put 60 days. If they tell me 60 days, I'm finding a different lender.
So you don't put the exact day, you just put 40 days or.
No, you put a date.
I did.
You have to put a date. Financing. Nicole. Read that one.
Buyer's obligation to purchase property is contingent upon the buyer's obligation, obligating a loan secured by property is solid.
Yep.
With the financing, FHA financing, USDA, assumption amendment, addendum, gift funds, owner, class, other five.
Okay, so there's all kinds of different financing contingencies, correct? So in the documents, you'll find, and the lender's gonna tell you what type of loan the person had. If it's an FHA, you're gonna use the FHA financing addendum. If it's USDA, you're gonna use the USDA. If it's cash, are you gonna use a financing contingency?
No.
No. Are you gonna use an appraisal contingency?
Yes.
Depends on the buyer. What if the buyer doesn't want an appraisal? Does he have to?
No.
No. Do all these others have to have an appraisal?
But don't you have, when a buyer pays cash, don't you want to have proof that the cash exists?
Yeah,
That means that should come here.
yeah.
Proof of funds.
You should have that before you're even starting to show them houses.
Okay.
that should be in the pre-form.
Yeah, if you're working with somebody that says, I have cash, and I want to buy a house.
Mhm.
Okay, great. We need your statement that shows you've got those funds. 'Cause otherwise, you could be driving around the neighborhood showing them 50 million different houses and he can't even buy the birdhouse from Walmart.
So you're gonna already know whether they using FHA or VA.
Yes, the lender's gonna tell you what is gonna be the best loan program for that person to use. In this area, a lot of times they use USDA because most first-time home buyers don't have a lot of money to put down. So there's certain areas where they can get in with no money down. Now, if it's within the city of Hagerstown, it's gonna be FHA. And then they may be able to use funds that are available through grants through the home store. That's the Maryland Mortgage Program. That is still considered FHA, but you're gonna check other along with FHA, and you're gonna put Maryland Mortgage Program. Because that means they're getting funds from the Maryland Mortgage Program, either toward closing costs or for down payment assistance. Because they do offer that.
This would be for first time.
Yeah, those, well, not all. Some Maryland mortgage programs are available to others as well. Depending on the situation, depending on the location. One of the things that I used to recommend people do is go to the home store and listen to their spiel. And when I am working with buyers, I will tell them they should sign up to take that class at the home store if they want to, and if they're in a low enough income bracket to qualify for that money, go to the home store. However, when you go to the home store, there's gonna be a real estate agent there that's gonna be teaching the class. There'll be a home inspector there. There's gonna be a lender there. They want your business. You can let them know you're already working with an agent and they will leave you alone.
What is the USDA? I've
That is through the Department of Agriculture.
never eaten in there.
Yeah, USD, that's understandable because down there they don't have it.
So, I mean, is that?
It's more for rural housing.
Yeah, farm.
There's also a program through the USDA, it's called USDA Direct. Okay, USDA Direct, they would actually go directly to the Department of Agriculture out on Maryland Avenue and get approved for a loan through them. They have to be below a certain income limit. So if you have somebody that you're working with, and this is a perfect example, their income limit only allows them to purchase a home for, say, 100,000, 125,000, 90,000. Really hard to find a home in a USDA location that meets that criteria. So with that small amount, that tells me they're not making a whole lot of money. So they can go to the Department of Agriculture and get what they call a USDA direct loan. It's a subsidized loan. They pay 1% interest for 30 years, or as long as they qualify. And the loan term is actually 38 years. So the remaining 8 years, they will be paying that subsidized interest back. Okay? What that does for your buyer is it takes them from, and I've done it on a couple transactions, it takes them from like $125,000 home to now $175,000 home.
Paying it off early?
What's that?
Is there any penalty for paying it off early?
No.
You have to be-
But very few people qualify for it because of the income limit. Because there is a income limit that you cannot go over to qualify for it.
So is this more specifically for farms?
No.
No.
You can't buy a farm with a USDA loan. You can't buy anything that has over 5 acres with a USDA loan. It has to be a modest home.
Sounds to me like it might be good for us to have a financing class.
Yeah.
Yeah, sorry. Yeah. Before, we will get that on the schedule.
Yeah.
I have a question. On
Go ahead.
So if, I'm assuming that we will check the other, they receive grants from the city or any other, government or-
Yeah. And then gift of funds. If you know mom and dad are giving Junior and his new bride $10,000 to buy the home, you've got to have that addendum. And it's a gift of funds addendum. Because the seller has to know that they're being gifted funds to go to closing. And if at the last minute, mom and dad have a falling out with Junior and the bride, and they're not gonna get the money, then that's just created a whole big problem.
So I assume that addendum would have to be signed by,
That addendum does get signed by the person that's gifting the money, and the person that's gifting the money, the bank has to verify that they have that money. And not only does the bank have to verify that they have that money, they have to see where that money came from.
they just keep it thing.
Yes. Very- Very strict.
Commercial and farming loans, also other.
This is not a commercial contract, so it's not going to apply.
What was the assumption addendum again?
What's
Yeah.
that?
Assumption.
Assumption addendum.
You don't see assumptions much right now.
It's a lower.
And the reason you don't see the assumptions are because interest rates are low. Back probably in the 80s, there were people that were assuming loans. There's only several types of loans that are assumable, okay? Which are FHA and VA. Those are the only 2 loans that are assumable. And what that means is the person would have to qualify for the loan and they would take it over. So we're not seeing that right now. You're not gonna see that probably for a while, sometime.
3 more years.
Probably more than that, because they're gonna try and artificially keep things down for a while. So the banking system fails.
I have a question about the USDA direct. If it's a below, like you have to be below a certain income level? you
Yep.
said?
Yep.
So with that stipulation, are they still approved based on several things?
They're still gonna be approved.
Income, I mean, their credit,
Yeah, they're still gonna, if they, yeah, they'll still be approved. It's just, they're gonna be able to get more money. And their approval process is more strict than the USDA rural guarantee. You have to have a minimum credit score of 650 to even qualify. Okay? Carrie, read number 10.
Financing, application and commitment. Buyer agrees to make a written application for the financing as herein described within blank days from the date of contract acceptance. The written financing commitment is not obtained by the buyer within 70 days from the date of acceptance. Seller at seller's election and upon written notice to buyer may declare this contract null and void and of no further legal effect, or buyer upon written notice to seller, which shall include written evidence from the lender of buyer's inability to obtain financing as provided in paragraph 9 of this contract, may declare this contract null and void and of no further legal effect. In either case, the deposit shall be dispersed in accordance with the deposit paragraph of this contract. If buyer has complied with all of the buyer's obligations under this contract, including those with respect to applying for financing and seeking to obtain financing, then the release of the deposit agreement shall provide that the deposit is, it shall be returned to the buyer.
What does that paragraph mean?
They have to get the loan within the date that's put here in order to the contract to go through.
Close. They're closed.
Well, the buyer has to put his application in within a certain.
Within a certain time frame, and then what?
And then it has to be, he has to be accepted for the loan.
It has to be, they have to provide a commitment letter for the loan
Right.
within so much time.
Right.
Typically, what I write in here is 7 days to apply for their loan. And keep in mind, with all contracts, your day count starts from the date of acceptance consecutively every day thereafter, including weekends and holidays.
What about if the contract is accepted at 11 p.m. on one day? Does that day count or it starts the next day?
It all starts at midnight that night.
So is it,
So if you got a ratified contract at 11 p.m. September
Yeah.
9th, day one would be today,
that day
today,
Yeah.
the day after.
after?
If you ratified it at 11 p.m. September 9th, the day count started September 10th. And that's the way it is in all the states. And your day count includes holidays and weekends.
That's business day. I mean, not business days.
It's not business days.
Calendar days.
It's every day, no matter what the day. So if you write the offer on December the 23rd, and you're only gonna put in 3 days to apply for the loan,
So we really have problems.
you got problems.
But most people apply for the loans beforehand, before they even look
Yeah.
for a house.
No.
No?
No, they get pre-approved.
Yeah,
Isn't that the
it's
same?
not it.
No, that's not the same thing.
No, but once you're pre-approved and you find the house, you call your lender and say, go ahead.
Once you find the house.
Yeah.
Then they go in to the lender and sit down with all their financial documents and make application for the loan.
It's like when you get a credit card, they can say you're pre-approved, doesn't mean you get to.
Yeah, you can get a credit card offer in the mail that says you're pre-qualified,
Doesn't mean anything.
and you can run around with that. I'm pre-qualified. I'm pre-qualified. Can you spend it? Well, no. So. Bonnie, read number 11.
Hang on,
Oh, go ahead.
what goes in the other?
Oh, I'm sorry.
Okay.
I will typically put the day after closing.
financing is not obtained by the buyer.
What do you mean?
That's
the day after
sneaky.
closing?
I've never seen that happen.
I do it all the time.
How does? I would pick that up any
Well,
time.
Sonia, Sonia, what do you usually put?
I just put, you know, anything above 30 and between 30 and 45, if I'm making a 45, you know,
30 days out. That's a smart time.
I always look, I always count my days out. The day of closing might be on the 17th. And I'll count the days out to the 18th and I'll put the 18th.
So you put a specific date.
Yeah, well, you put the number of days.
You don't want to take a chance that the contract.
I don't want to, I don't want to take the chance that we get all the way to the day of closing
Or, you know.
and now they can't get the loan. They've been denied. Well, we had, if we put in there 30 days and 30 days comes and we still got 10 more days to close and they're denied the loan, buyer's probably going to lose his deposit
Whereas.
because he did not provide commitment within the time frame specified.
Would he be able, if you don't do that, if you do what you say, then he can go to another bank or he could try something else.
We'll get there. We're not even worried about that right now.
So you give them extra days.
All I do is take it to the day after that we're supposed to close
Which is merely for the protection.
of the buyer's earnest money deposit.
But it's the selling agent. What
Anybody ever question you on that?
No,
They've never even picked up.
never even, they just,
So
they don't say, they accept my offers.
Has that happened to you, like, they get the mud?
Yeah.
Days,
Yeah.
start screaming.
Just remember, you can always extend it.
But why would a
Extend,
seller
extend.
accept that?
Huh?
Why would a seller accept that?
They do. Doesn't matter to me, it's as long as they did it. Because, and here's the thing, here's why most sellers accept it. And the reason that we're doing this contract today, the way we're doing it, is because most real estate agents do not read the contract, don't know what's in the contract, and don't present the contract the way it's supposed to. They just say, sign here.
That's true.
And you, at that point, are doing a big disservice to your client. And you will eventually make it to court and make it before the real estate commission. They'll say, come on down.
But you won't, because you're here.
Right.
You're here in this room.
Okay. Yeah. Okay. Who did I ask to read number 11? You, Tony? Yep, go ahead, number 11.
Okay, alternate financing. Provided buyer timely and diligently pursues the financing described in the financing paragraph, the financing application and commitment paragraph, and the buyer responsibility paragraph. Buyer at buyer's election may also apply for alternate financing. If buyer at buyer's sole option obtains a written commitment for the financing as described in the financing paragraph.
Let me skip.
Oh, financing in which the loan amount, term of note, amortization period, interest rate, down payment, or loan program differ from the financing as described in the financing paragraph, or any addendum to this contract, the financing application and commitment paragraph, or any addendum to this contract shall be deemed to have been fully satisfied. Such alternate financing may not increase costs to seller or exceed the time allowed to secure the financing commitment as provided in the financing application and commitment paragraph, or any addendum to this contract.
What does that paragraph mean?
So that means what I'm saying, if you get that extra 10 days before the date's up, that gives permission to the buyer to go to another bank, try to get a loan, or use some other type of finance.
No.
Would they get turned down again?
Because they're, as long as they're
Because-
abiding by the date.
Here's, you cannot extend it and it cannot cost the seller any additional money.
Right, but if it's within that, it's giving them permission to pursue. a
If it's
loan.
within what?
If it's within the timeframes that was set, and it's not gonna cost the seller any additional money.
So if they have to provide commitment within 30 days, and they wait until they're 10 days away from closing, are they gonna be able to get a loan and close it in 10 days?
Probably not.
So you're not within your time frame. A buyer can only seek alternate financing at the same time that they apply for their loan with the original lender. They can compete for lower interest rates and seek alternate financing. As long as they apply for the alternate financing within what? 7 days.
So they do it simultaneously.
They have to do it simultaneously.
So they could apply for an FHA and also a regular bank.
Yes. They can switch the financing if the lender says that they're gonna switch it from USDA to FHA, provided it's not going to create more expense for the seller, and providing it's not going to create a closing date later than what was already agreed upon. Unless all parties do what? Agree to extend.
So what would be the motivating factor for them to do that?
A lot of times with USDA, lenders don't do their job the way that they should. And they'll look at it and qualify them USDA and say everything looks good, and then at the last minute, oh, you make too much money. You can't apply for USDA. You have to go FHA.
Or interest rates too?
Interest rates change, but usually by that point, you've got your rate locked in, so it really doesn't matter.
So then the addendum, you just changed it, have an addendum?
You just have an
Different
addendum that
addendum
switches
right now.
the financing from USDA to FHA or FHA to conventional, and all parties have to agree.
Or an addendum that increases the time and the seller has to.
If they agree,
So when you're doing your offer, do you explain paragraph 11 to the buyer?
what I tell the buyer is exactly what this paragraph says. It says that you have so much time to apply for your loan. We're gonna do it within 7 days. We've got 46 days to get commitment from the lender. We're gonna close on the 45th day. If you need to seek alternate financing because they can't get you that loan, we need to do it within the time frame specified. So you need to be in touch with your lender and make sure that your lender knows the timeframes and get you approved. Because otherwise you can lose your deposit.
But if you were to apply for, let's say, 2 different ones at the same time,
Your lender, and this is, and we're starting to get a little too much into lending part of it. The only thing you're worried about is that if they're gonna apply for alternate financing, they need to do it ahead of time. Their lender should already know whether or not they're good to get it. If you have a lender that calls you a week to 2 weeks out of closing and says, we can't use this loan, that lender screwed up. He did not do what he was supposed to do when he did everything to begin with.
I do have a question. I have a client who's buying a new construction loan. They could not, well, they kind of got the loan approved within 15 days so that the.
Kind of got the loan approved?
Well, they did. So the contract could be ratified. However, they're gonna have to reapply, I would say 3 months before they get the house, because it's gonna take 9 to 10 months for them to finish,
Not uncommon,
right?
unless they're
So
doing a
how would that
construction
work?
loan. Well, if they put anything on credit, or if they use any credit, or if they lose a job or anything like that in the process,
Uh-huh.
they're screwed.
And they lose their money?
They lose their deposit. That's why it's really important when you have your buyer consultation, talk to your buyer and say, do not buy anything on credit. Even if you're going over to look at new furniture for the new house and they say there's no payments for 3 years. Don't do it. And chances are, if you go to closing and they come rolling up in a new car, you're not closing. That has happened.
Okay.
Cause they
So,
said,
oh,
oh,
don't
it's
change
great,
your job.
going to closing today, I'm
Stay
gonna
the
get the
same.
money.
Is that just fix
You
it?
don't do anything.
Open the
Okay.
door, fix.
Yeah, it's just opening up another line of credit. It's gonna tank it. Forget it, done. So they can't do anything.
So that 7 days is your general business?
That's my general rule, because within 7 days, there's no reason you shouldn't be able to apply for your loan. You've already started the process. We've already been going out looking at multiple homes and yeah. Gail, number 12.
Number 12, home and your environmental inspection. Buyer acknowledges, subject to seller acceptance, that buyer is afforded the opportunity at buyer's sole cost and expense to condition buyer's purchase of the property upon a home inspection and or environmental inspection in order to ascertain the physical condition of the property or the existence of environmental hazards. If the buyer desires a home inspection and or environmental inspection contingency, such contingency must be included in an addendum to this contract. Buyer and seller acknowledge that brokers, agents, or sub-agents are not responsible for the existence or discovery of property defects. And then it has inspections, addenda attached, buyer, inspections declined, buyer.
What does that paragraph mean?
Buyer has a right to have inspections for environmental.
That's a real estate agent.
He has to pay for it.
Yeah, their expense.
Buyer can do inspections at their expense. What inspections can they do?
What do they
Are you
specify?
sure?
Oh, they just do
They
the
have to
home
specify.
inspection, termite inspection.
Termite's not even part of the inspection.
They could do
I mean, so you can do
radon, they
anything.
can do, you know.
It tells you that all inspections have to be attached by an addendum. And there is an inspection addendum which lists all the different inspection addendums. What if the property is being sold as is?
You can see.
They still can do it, but it will
Just
not
for
affect
information.
Then you have to add the as-is addendum. So when I get that question, when people say, do I need the inspections addendum uploaded because it's as is? Or if we bought it as is without inspections, do I need it uploaded? Yes, you need one of those two documents uploaded. It is required. It says in the contract that the as-is addendum or the inspections addendum are required.
But you can have both, because you can buy it.
You
as-
cannot have both.
Why not? Because if I, even so I acknowledge the lease price, but I would like to know what's wrong with our house before I make the decision.
So
I take
you're
it
going,
as
so
is.
then you're doing as is.
Where does it say, as is? We didn't get to that yet, did we?
No, but wait a moment, you have to say, I want property inspection, because that just happened to me.
You want a property inspection and you're saying that you want the property inspection.
No.
You either need to attach the inspections
No.
addendum. It tells you right here that you need to attach the inspections addendum.
Yeah.
Or if you're willing to do the inspections as is, then you attach the as is addendum. The
So I
as is
can go
addendum lets
get
you,
my
the
deposit.
as is addendum will allow you to do any and all inspections that you wish to do.
And walk away if I don't like the
Correct.
instructions.
And get your
my
deposit back.
back.
Yes. And the inspections addendum, you're going to go through that inspections addendum if the property is not being sold as is. Usually if a property is being sold as is, it will be in the notes.
Yeah.
And the listing agent should have the as is addendum uploaded in the disclosure.
So
Yes.
if it's in the notes, but however, they don't have the addendum, then it's a no-go for the as is.
Well, if they didn't put the as is addendum in the disclosure, and you send them the inspections, the inspections addendum spelling out your different inspection, then they're gonna be bound by the inspections addendum.
I was, I guess mistakenly under the impression you bought something as is. I just think then you could have inspection, but if you do, you can still turn down the house.
Yeah.
I thought that was the whole purpose of as is.
No,
As is
If
started.
you're doing, it depends on whether or not you're doing as is with inspections or as is without inspections. If they decline inspections on here, then you don't have to worry about the as is addendum or the inspections addendum, because they've declined inspection. So they're not gonna hold any inspection.
The as-is inspections addendum, or the as-is addendum says, as is with inspections and right to terminate. So you can do any inspections you want. If you don't like it for whatever reason, you can turn away or walk away. Or you can take it as is with no inspection.
It's on the as is addendum.
Oh, it's not in here.
No. But it's telling you, you have to have an inspections addendum attached.
Correct.
So the inspections addendum or either the inspections addendum where you're going to choose your inspection,
Right.
or an as-is addendum with the right to inspect and terminate.
So we just have to explain that to them, that there is an as is addendum.
If the listing agent has done his job the way that he is supposed to, the as-is addendum will be in the disclosure.
Oh, okay.
And you're already going to know when you're
Because
filling
he's
this
saying
out.
that. Okay, yes.
Yeah. Steve.
Yeah.
Number 13.
Inclusion, exclusion, included in the purchase price are permanently attached fixtures, including all smoke detectors, certain other now existing items, which may be considered personal property, whether installed or stored upon the property, are included if the box below is checked. Included alarm system.
Now, I'm not gonna have you read through all these items. Everybody sees all these items, correct? This is where you fill out from the items that convey that was provided to you by the listing agent in the disclosure. So whatever is on that items to convey list, you will go through and mark them. I never want to see attached. Here's why. On the items to convey document for Maryland, it specifically states on top of it, not to be used in the contract of sale. So if you go to court because the dishwasher was supposed to stay and you put see attached, the first thing that happens is that that see attached item, that's not part of the contract. That gets thrown away. A lawyer will argue that that's not part of the contract. It states it's not part of the contract. It cannot be part of the contract. They'll get rid of it. Yes.
If something is listed on the MLS, such as a dishwasher, but not listed on there, what's the reality of that? So aren't you making an offer on the MLS?
You should be making an offer on the documents that they provided.
So if
Now-
my client fills this out and doesn't put the dishwasher on there, but I put the dishwasher on the MLS, then what happens?
You're buying somebody a dishwasher.
Because it's on the MLS.
No. Just because they're gonna fight and argue over it, and you're gonna buy a dishwasher.
But that's what I'm saying. It's just like, I mean, what, would they have a significant argument if it's on the MLS but not in the exclusions paper? Or
Well, I'll put it to you this way. I did have a heat pump installed for somebody because it was marked in the MLS and it was marked in the documents that it was a heat pump, and it wasn't. It was a straight air conditioning.
now that almost happened to me one time, so yeah, that stinks.
And the other agent got angry because I said, well, no, it says it's a heat pump. It even says on your documents, it's a heat pump. That is not a heat pump. They bought the house thinking it was a heat pump.
It's not worth going to court and ruining your reputation. You just buy them the dishwasher.
Yep. You got
Then the
it.
question is, what kind of dishwasher are they gonna get from me?
My kid will be over there at 5 o'clock every day. Yeah.
Nothing about it, but it's not working back there. So if we do the final walkthrough in their, items in there that are not on the list, and the seller doesn't do it, then the ownership goes to the buyer.
Not necessarily. Because when you do your final walkthrough, you have a document that says you're doing a final walkthrough. And if there's items that are left behind that were not supposed to be left behind because they didn't say they were excluded, seller needs to remove them. Because it's probably gonna cost a good bit of money to have those items removed from the buyer. The buyer should not have to pay to have those items removed.
So you shouldn't really do the walkthrough on the day. Should you?
You can do the walkthrough up to 5 days before closing. Okay? I always recommend that you do the walkthrough with enough time to realize that either everything's correct or it's not. Usually the day before. That way, that gives them time, and you have time to submit a document to them that says, you don't have it the way it's supposed to be. You left this, and this, or it could be a situation where you're gonna make them escrow funds because you got there, holy crap, they're supposed to move out, and they're still living there. Now we're in trouble. Yes, that's happened. Yes, you will see it. So part of your responsibility as a listing agent is to make sure that your seller knows they gotta be out. All of their stuff has to be out by the day of closing. So they should be working on getting that house empty before closing. Yes.
Totally off subject, but when can a lot be changed? They are closing after paperwork.
After the new buyer takes possession of the property,
Well, that's her question.
when can the locks be changed? So you will never put in here, see attached, because there should never be anything attached. You're going to use that list that they give you to check the items that convey. Now, what happens if the washer and dryer are not checked on here, but you want them to stay? Then you're going to add washer and dryer, you're going to add the checkbox to it. You're going to initial next to it, and then you're going to put additional inclusions so that it comes to their attention that you want the washer and dryer. And then they will either agree or cross it out. Go ahead.
There isn't a document
seller bought something and all the furniture and everything was included, so there was 2 pages of items. Individualized each room. So they wouldn't be able to fit on here, and there were items that's not listed. There should be an additional document listing.
That would be on an addendum. That's not gonna be on the items to convey. That's not part of the contract. Okay,
Okay, but what if you're the seller and you're moving out and then all of a sudden you decide, you know, we're not gonna take this washer and dryer. We were going to, but we're not because we'll just buy a new set.
if you've already agreed that the washer and dryer was not going to stay, then the purchaser may have bought a washer and dryer, get it gone, or talk to the other person and find out that they mind if it stayed. Because sellers will do that a lot. They'll say, oh, it's too late, I don't feel like moving that, I'm not gonna move it, let's see if they just want it. We'll just leave it here, they can have it. Doesn't work that way, they come in there, they might not want it. I don't want that thing, that thing's ugly. Get it out of here.
Sell it on market.
So seller's responsible for getting it out, not the buyer. If they're gonna make the buyer responsible for getting it out, then you, as the buyer's agent, are gonna say, okay, buyer will get it out, but we're gonna need to hold 1.5 times the amount in escrow of what it's gonna cost to have it removed.
What if you offer it to them and they, to see if they want it, and they do decide they want it?
Then that's okay.
Is there a time limit on that? Can you do that at the closing table? Let's say our walkthrough is that day, our final walkthrough is that day.
If you do the final walkthrough that day and everything's not the way that it's supposed to be, then you should be asking for an escrow to be held. Some title companies won't hold an escrow, but there's a problem. So now, if they're not gonna hold an escrow, then we need a delay. Because they gotta finish getting all their junk out.
That's not at the fault of the buyer, that. the
Correct.
money's been in the contract.
Correct.
If we decided not to bring the snow blower, well, we could choose them and they kept it.
Well, as long as everybody agrees. Pam, number 15. Did I? Pam, number 14.
Agriculturally assessed property. The agricultural used assessment is a reduced property tax assessment for agricultural land. To be eligible for the assessment, the land must be actively used for agricultural purposes. The agricultural land transfer tax is a tax imposed under section 13-301 of the tax property article and noted Code of Maryland. If the property is assessed in the agricultural use category and the buyer does not intend to use the property for agricultural purposes, the tax may become due and could be substantial. The tax is imposed on the deed itself and must be paid before the deed can be recorded. At the time of sale, seller shall notify buyer in writing that the transfer may be subject to the tax. Buyer will be responsible to pay the tax unless the parties negotiate a different agreement. To avoid paying the tax, buyer must continue to use the property for agricultural purposes and comply with the other requirements of the law. The property or any portion thereof may be subject to an agricultural land transfer tax as imposed by section 13-301 of the tax property article and noted Code of Maryland by reason of the property having been assessed on the basis of agricultural use. The tax assessed as a result of this transfer shall be paid by.
Now, if the property is in an agriculturally assessed status, the seller has to inform you. As a buyer, if they want to keep it agriculturally assessed, there's documents that they have to fill out before closing to submit at closing to keep it in the agriculturally assessed status. Because they do get a rather decent tax break on the property. You'll find this mainly with farm or with land that a house hasn't been built on yet that is greater than 5 acres. Okay? You can negotiate who's going to pay the transfer tax if it's going to be due. The buyer determines if it's going to be due. How does the buyer determine if it's going to be due? Because it says if the buyer is going to keep it in the agriculturally assessed value, they need to make the application for agriculturally assessed value exemption. If they're not going to keep it in the agriculturally assessed value, then they're going to pay the agriculturally assessed tax. So if the buyer knows he's not keeping it in the assessed value, he may ask the seller to pay that. It is substantial.
Is it like accumulated, like you've been getting a break on your property taxes for 5 years, and now you're gonna sell it? So now the break that you were getting for 5 years, so.
Yeah.
So is it possible to say you could use it as a farm and plant?
Yeah, and that's the reasoning that they have to fill out documentation before closing, saying that they're keeping it in the agriculturally assessed value, and it has to be an approved agricultural business.
So you can't just.
Well, the agricultural business could be, I sold a piece of ground on Old National Pike to a gentleman. They weren't planning on building a house on it. It was agriculturally assessed. They were getting a break because they were using, the person before was using it as a tree farm. Weren't any tricky trees on it. But it was a tree farm. That was an approved method. Because there were no trees on it, when they went to renew the agriculturally assessed value, they would not allow them to use it as a tree farm. So they ended up having to use it for honey production. Honey production. Yes. So they put, I think they had to put like 10 or 12 beehives on the property. They said, okay. And they're getting a substantial savings. So the buyer's gonna know, developers, when they're buying a large tract, they're gonna know if they're taking out of the assessed value. They'll probably keep it in at first and then take it out piece by piece. Yes,
When filling out the contract, if you're unaware of the status, if you're a buyer's agent, is it best to always just include saying the seller will pay it? Or you need to have that defined before completing the contract?
typically what you're gonna find with residential property is it's not going to be in agriculture unless it's a farm. And then if it's a farm, then, yeah, you're gonna know. Because you'll see it in the tax record, and it'll note when you go to SDAT, if it's agriculturally assessed, or if it's in forest conservation, which is the next one, number 15.
So for this one, you say NA?
You can say NA. A lot of times I just leave it blank because I know, although we're not supposed to leave it blank, but a lot of times I do. I just don't put anything there because I know it doesn't apply. Most residential property, it doesn't apply. What you will find applies with a lot of residential property in Washington County is number 15. And Diane, why don't you go ahead and read that one? Or Denise, I'm sorry.
What?
I thought- Read number 15.
Forest Conservation and Management Program. Buyer is hereby notified that this transfer may be subject to the Forest Conservation and Management Program imposed by Section A-211 of the Tax Property Article. Annotated Code of Maryland. Forest Conservation and Management Program taxes assessed as a result of this transfer shall be paid back.
This is one that you're gonna find a lot on properties in Washington County that have 5 or more acres. There's quite a few, believe it or not. They're in forest conservation through the Department of Natural Resources. It will reflect that under the SDAT. And it will say that it's in forest conservation. In order to keep it in forest conservation, there's documentation that needs to be filled out prior to closing, so that it can be submitted and approved after it goes to closing. The documentation you can get from the title company that you're using for either the agricultural or for the forest conservation. A lot of times, some title companies will tell you to contact DNR. You can go on DNR's website and you can download the document from there. And have your seller or your buyer fill it out. You do not fill it out.
Now, is this something that appears that they can keep?
Yes. Because you get your tax break.
Mm-hmm.
Under forest conservation, you cannot cut any more than 43,560 square feet of timber.
That's over an acre.
Square mile.
What is it?
Isn't this over an acre?
No,
43,000 square feet?
43,560 square feet of timber.
An acre.
An acre.
No, it's not.
Why not?
Timber's not. an
Timber's not an acre.
Oh,
You might get 1,000 board feet out of one tree.
Hmm.
You might get more. You might get less.
so you can cut down 50 acres.
No,
of trees. No?
what they're gonna allow you to cut is very minuscule.
How many?
Believe it or
trees?
not, 43,500 square feet of timber
How many trees?
is approximately 15 to 20 trees. Which is equivalent to approximately a quarter to a half an acre, depending on how far they're spread out. They don't want the land to be forested, but they want you to be able to cut enough to place a home on it. That's it. That's why it's 43,560 square feet of timber.
So the buyer has to fill out the paperwork saying they're gonna keep it. And nobody pays the tax, right? The transfer.
Correct.
Okay.
Now, if the buyer doesn't fill it out, then the buyer's gonna be responsible for paying it. Because they've already taken possession of the property, and took it out. You need to make sure that your buyer is going to keep it agriculturally or in forest conservation, that they fill out the paperwork. Let's see. Adrian, you're smiling too much. Number 16.
Lead-based paint. A federal lead-based paint law, Title X, Section 1018, the Residential Lead-Based Paint Hazard Reduction Act of 1992, the Act requires the disclosure by seller of information regarding lead-based paint and lead-based paint hazards in connection with the sale of any residential real property on which a residential dwelling was constructed prior to 1978. Unless otherwise exempt by the act, the disclosure shall be made on the required federal disclosure of information on lead-based paint and or lead-based paint hazards form. Seller and any agent involved in the transaction are required to retain a copy of the completed lead-based paint disclosure form for a period of 3 years following the date of settlement. A seller who fails to give the required lead-based paint disclosure form and EPA pamphlet may be liable under the act for 3 times the amount of damages and may be subject to both civil and criminal penalties. Buyer acknowledges by buyer's initials below that buyer has read and understands the provisions of paragraph 16A.
Okay. Everybody understand that one? What if the house was built in 1979? You need the lead-based paint form? Not in Maryland.
If it was built before that, you need the form.
If it was built before that, you do need the lead-based paint form. And you will need the pamphlet, the brochure. It talks about protecting your family from lead.
What's this 3 year?
You gotta keep this form for 3 years. How long do you have to keep contracts for? 5 years.
Do they have to be
Sure.
hard copies?
In West Virginia.
No,
Does not have to be a hard
doesn't have to
copy.
be a hard copy.
In West Virginia.
So the seller, he's the one that has to get the form and the pamphlet?
Well, we provide them with the form,
Okay,
and we provide them with the pamphlet
okay.
as a listing.
But it says keep it for 3 years, but isn't he gonna pass that on to the buyer?
But he's also gonna have a copy.
Oh, okay.
But these are hyperlinks within in the digital form. These are hyperlinks to the documents that's needed, right?
Yes. But how long should you keep it for?
3 years is it?
I'm used to the part of the contract.
So let's go back to real estate school. How long did they tell you that you would need to keep records of your sales?
7
7 years.
Right, so it's fine.
So the reason that we keep records of the sales, these contracts, is because a buyer has how long from the time that they discover a default from the property that they purchased.
Is it 18 months?
1 year? 3 years?
2 years. 2 years. 2 years.
A buyer can file a claim against a seller in Maryland for up to 3 years after discovering a default that was not disclosed.
So it's forever. After a default.
How long do we keep our documents? Forever.
Oh, that's interesting. So now. What constitutes a-
So if the agent leave Keller Williams, if we was to leave Keller Williams, do we need to request the documents from you? If we have an issue, or is that your responsibility to provide it to the client?
Well, anytime that documents are signed, they're always provided to the buyer or the seller. Once everything's been ratified.
However, they lose the document. They come back to you and ask for
They
it.
can come back to you and ask for them, and you should be able to provide them to them.
How long should the,
So if we are no longer with the brokerage, that's what I'm saying, they come to us, can we get them from you? That's my whole question.
Most likely, yes.
but the seller
because-
should keep his
The
contract?
seller should keep his copy, the buyer should keep their copy, and the agent should keep their copy,
But
and
isn't
then
it-
Keller Williams should also keep a copy.
But if worse comes to worse, isn't there, the state of Maryland, a website where you can download it?
No,
I can download the settlement sheet.
from how long ago?
I don't know.
a question. Suppose it's something that would have been discovered if you'd had a home inspection. But the buyer opts not to do that. And then 2 years later,
But if it would have been discovered on a home inspection, therefore it would have been readily available to be seen. And therefore the discovery was on the seller to disclose it. Because it states, and we'll get there, that you have to, as a seller, unless you're an exempt person, you have to disclose, either do a disclosure or a disclaimer. And if you're doing a disclaimer, you have to disclose all defects, latent and material.
okay, our next door neighbor bought this house. Didn't have an inspection. Discovered later on that the house is not septic, it was had a cesspool. And it ended up collapsing. He went after the buyer, but he finally gave up.
You mean he went after the seller?
The seller, because he finally gave up the lawsuit, and now banks got it. He just stopped paying on it and everything. But
He probably shouldn't have done that, because he probably would have won.
They didn't disclose it was a cesspool over a septic. I mean,
That's a big issue.
That's a
But
huge.
very strange because banks don't let.
They don't
lend
lend
on-
on.
They don't lend on cesspools.
Yeah, so how
Oh, they
they get
don't?
mortgage?
Oh.
It's interesting, because
So the seller probably knew that and just decided not to say he had a cesspool so he could sell
He
it.
probably would have won. And they would have probably had to replace the cesspool with a septic and all that good stuff. Sonia, what's B?
Renovation, repair, painting of property in accordance with the lead renovation, repair, and painting rule as adopted by the Environmental Protection Agency effective April 22nd, 2010. The improvements on the property were built before 1978. Contractors engaged in by seller to renovate, repair, or paint the property must be certified by the EPA where such work will disturb more than 6 square feet of paint per room for interior projects, more than 20 square feet of paint for any exterior project, or includes window replacement or demolition. Before and or during any covered work project, contractors must comply with the requirements of the RPR. A seller who personally performs any covered work on rental property is required to be certified by the EPA prior to performing such covered work. No certification is required for a seller who personally performs covered work on a seller's principal residence. However, seller has the ultimate responsibility for the safety of the seller's family or children while performing such covered work. For detailed information regarding the RRP, seller should visit blah, blah, blah. Buyer acknowledges buyer's initials.
So what does that paragraph mean?
Contractor has to be certified in lead paint, but the seller can repaint themselves and not have to.
Does it say they don't have to abide by the EPA regulations?
No, no certification is required for seller who personally performs it. However, the seller is ultimately responsible for the safety of the seller's family or children.
So does the seller have to be certified by the EPA?
No.
Does the seller have to abide by the EPA guidelines?
I don't think so. No.
It's only strongly recommended. All right, who wants to do C? Who hasn't read yet?
see, Maryland Lead Poisoning Prevention Program. Under the Maryland Lead Poisoning Prevention Program, the Maryland program, any residential dwelling constructed prior to 1978 that is leased for residential purposes is required to be registered with the Maryland Department of the Environment, MDE. If the property was built prior to 1978 and it's now or has been a rental property or may become a rental property in the future, a separate Maryland lead-based paint disclosure form is attached. Detailed information regarding compliance requirements may be obtained at mde.state.md and on and on.
What does that one mean?
You just have to be covered under that program.
For a landlord, you have to
Yeah.
register the home.
Yes.
with the state.
If the property was ever used as a rental, it has to be registered in the lead poisoning prevention program. If it was registered in the lead poisoning prevention program, then it also has to be disclosed if there was ever anybody that had a high lead poison blood drawn. That has to be disclosed. So if you own a rental property and it has lead-based paint in it, you're going to have the lead poisoning prevention, you're gonna register in the lead poisoning prevention program. If one of your tenants goes for blood work and lead is found to be high, you as the landlord are gonna be held responsible, and you're gonna be responsible for making sure that their healthcare costs are going to be covered. If a buyer, if it's never been used as a rental property, and it's going to be turned into a rental property, it will have to be registered in the lead poisoning prevention program. And if that property was ever registered prior to that owner selling it, then the next person buying, so if it skipped ownership for a year, if it was a rental and then became
Private.
an owner occupant, and then it goes back to being a rental, they'll need to, when they register it, it will automatically flag it that somebody has tested positive for lead, and that would need to be disclosed to that potential person that's going to be renting it out.
Question though. If any of this don't apply to my buyer, do they still have to?
They still
that?
initial it because it's based, because it says that the buyer acknowledges by the buyer's initials below that the buyer has read. Notice it says the buyer has read and understands paragraph and then the paragraph.
Always initial pretty much.
You're always going to initial. Jerry, how about number 17?
Notice regarding disclosure of deferred water and sewer assessment. Pursuant to section 14.117(a)(5) of the real property article of the annotated code of Maryland, a contract for the resale of residential real property that is served by public water or wastewater facilities for which deferred water and sewer charges have been established by a recorded covenant or declaration shall contain a notice disclosing information about the deferred water and sewer charges. If a seller subject to this law fails to comply, A, prior to settlement, the buyer is entitled to rescind in writing the sales contract without penalty or liability. On rescission, the buyer is also entitled to the full return of any deposits made on account of the sales contract. If any deposits are held in trust by a licensed real estate broker, the return of the deposits to a buyer under this law shall comply with the procedures under section 17-505 of the Business Occupations and Professions article of the annotated code of Maryland. Buyer's right of rescission shall terminate 5 days after the seller provides to buyer written notice in accordance with this requirement. And B, after settlement, the seller shall be liable to the buyer for the full amount of any fee or assessment not disclosed. unless the seller was never charged a fee or assessment to defray the costs of public water or wastewater facilities by the developer, a successor of the developer, or a subsequent assignment. This law does not apply in a county that has adopted a disclosure requirement that is substantially similar to this law. If the property is served by public water or wastewater facilities for which deferred water and sewer charges have been established by a recorded covenant or declaration, sorry. I needed a break. Notice regarding deferred water and sewer charges.
What does that paragraph mean?
You want me to read and comprehend at the same time? Lenny?
Maybe it's killing us.
Right. See, everyone's reading.
So I'll make it easy. That paragraph says that if it is in a deferred water and sewer payment, if there's a deferred water and sewer payment that's on that, that means the person has more than one water and sewer bill. There are a couple developments in Washington County, and there's many as you get east of Washington County, that they have a deferred water and sewer. The deferred water and sewer was put into place for companies to build homes and add public water and sewer. So the company paid for the water and sewer on behalf of the county, and they want their money back. So the county had no way to pay them back other than to charge an additional fee for water and sewer. So that additional water and sewer fee is paid for a period of time. If the seller has an additional water and sewer fee and he does not disclose it to a buyer, prior to closing, the buyer can terminate the agreement at any point and get his deposit back. If it closes, the seller is responsible for payment of that bill for the following 5 years. Wow,
There you go.
that's what that paragraph means.
Okay.
Addendum and disclosures. You're going to go through this list of addendum, and the ones that are going to apply, you're going to check the ones that apply. They are an affiliated business disclosure notice. If you're going to be using Keller Mortgage, you're going to use an affiliated business disclosure form. If it's an as-is property, the as-is addendum. If they're going to be a backup contract, then the backup contract addendum will be attached. Cash appraisal contingency. If it's going to be a cash appraisal, you'll check it. If there's a conservation, if there's disclosure of licensee status. What is a disclosure of licensee status?
You, as a real estate agent, have an interest in the property.
And
You have to let the buyer know that
and
Related to the seller.
and
Have a financial interest.
disclosure of leased items addendum. If there are leased items, what are the most commonly leased items?
Propane tanks.
Yes, propane.
Is a satellite dish considered a leased item?
They are technically considered a leased item. However, DirecTV and what's the other one? Dish Network. They tend to put their equipment all over sprues.
And they still
And
leave it there. when
They'll
you
keep
leave
it there forever, but they want the other equipment back. Okay?
They won't take down the living general.
No, they won't take down because once it's on the roof, they won't take it down. Why won't they take it down?
I guess because they make a hole in the roof.
Well, it's also a fixture. But they want the rest of the equipment back. So it would be considered leased equipment. But they're not gonna take it this
Technically, yes, but
year. Solar panels,
If
Yeah,
they're
that's
leased.
a good one.
Oh, yeah.
they're leased. Sometimes they're more than leased. Does a person have to keep the leased equipment that's buying?
no,
No,
I think they have to take off a solar panel.
yeah, because that can be rather expensive. You don't want solar panels on the house. And somebody wants to buy the house and they don't want those panels, it might cost. On some of the ones that I figured out based on what they give you, it could be anywhere between $75,000 to $150,000 to have them removed.
You're kidding.
You know,
Better make a good case for keeping.
I'm sorry, Lenny, you're killing me.
I am just too old for these many-hour sessions.
hey, we told everybody it was gonna be wonderful. And
It
then
is.
an hour for questions after.
Oh.
Disclosure of leased items addendum. Disclosure of information on lead-based paint and or lead-based paint hazard. First time Maryland home buyer transfer and recordation tax. Okay. Are you gonna check this if the person's a first time home buyer? We haven't gone over that section of the contract yet. I'm gonna tell you right now, if they're a first time home buyer and you're not asking for it to be done differently than what's in the contract, you're not gonna use that addendum. Got that? We'll get there. Okay? Homeowners Association, if there is an HOA, you do have to provide notice that there's an HOA. If there is a kickout, what would a kickout be? House to sell contingency. That's really about the only way that you can kick it out, or a short sale contingency.
Wait, who's that? The seller, Has to sell
Or the
their-
buyer, yeah,
okay.
or the buyer. Local city county certifications and registration. Local city county notices and disclosures. Maryland lead poisoning prevention program disclosure. Maryland non-resident seller transfer withholding tax. If they are not a resident of Maryland, Maryland is going to withhold taxes on them. It only counts if it was a primary, it does not count if it was a primary resident for that person 3 of the last 5 years. Notice to the buyer and seller, Maryland Residential Real Property Disclosure Disclaimer Act. This is what I call the disclosure to disclosure. That always has to be in the documents. Notice of disclosure of the deferred water and sewer charges. On-site sewage disposal system inspection. So if it has a septic, you're gonna need that. A property inspections addendum. Property subject to ground rent. Purchase price escalation. If it's multiple offers and you're gonna be escalating the price up to a certain point, you will add that to the offer. Sale, financing, settlement, or lease of other real estate. So if the contract is going to be contingent on the sale of a property, it needs to be in there. Seller contribution. Seller's purchase of another property, a short sale, third-party approval, and water quality. And then it says any other addendum or special condition. So all of those may be addendums that you're going to need to add to this offer. Okay? You'll know when you go through that list based off of what is in the MLS. if you need those addenda. Okay? Any questions with that?
Yeah. So if the seller has to buy a house before he's willing to let you buy his house, he has to, the person doing the listing has to put that in the listing, that contingent on seller finding house of choice or whatever, right? And that clues you into knowing as a buyer that the buyer's
You gotta find a home of choice.
right. Is there a time contingent with that?
Depends on what they write.
Are you sitting in the seller home as you're going through this?
Not, this is the contract of sale. So
Okay,
you're
the
actually,
buyer.
you're actually sitting with the buyer at this time.
So if any of these addendums were needed, they should be attached, right?
Not necessarily.
Or do you have?
Depends on whether or not the listing agent did his job.
So, let's say he did, then they'd be.
If he did his job, then all the appropriate documents will be in the disclosures.
What if he didn't?
Then you have to use these, you have to get them and add them to it.
Mhm.
Or if you do not see the documents in bright where they're supposed to be, you call the listing agent, you say, I need all the disclosures.
You kind of just touched on what I was gonna ask, but for the HOA, how many documents are needed? So I'm assuming it's the notice to the buyer.
There's 3 sets of HOA documents. You will need all 3 sets. You'll need the notice that there's an HOA. You'll need the information about the HOA,
Which is, this, I'm assuming the fees and disclosure. is the name of it.
and then you'll need the transfer of the HOA document disclosure.
There's nothing in here that short sale, is that because that's a special? Does it say
Short sale.
Oh, it does, it does. So there's more than one of those, too. There's a bunch.
Oh, yeah, there's a bunch of those. And it's just like a condo. There's like 5 different condo docs. You end up really only needing, I think, 4 of them unless it's a brand new condo. And it just became a condo. That's going to be, because you have, if it's a condo, then you also have to provide them with the condo docs involved in the sale of the condo. Because when you buy a condo, you're only buying what's inside the walls and the common area. You'll get a certificate that shows that you're the owner of it. And that certificate that you need, that's a separate document to transfer the certificate. Okay. Paragraph 19. Go ahead.
Wood destroying insects inspection. Buyer's expense, if VA, then at seller's expense, is authorized to obtain a written report on the state regulated form from a Maryland licensed pest control company that, based on a careful visual inspection, there is no evidence of termite or other wood destroying insect infestation in the residence or within 3 feet of the residence. And damage due to previous infestation has been. The provisions of this paragraph also shall apply to 1, the garage or within 3 feet of the garage, whether attached or detached. 2, any outbuildings located within 3 feet of the residence or garage. And 3, a maximum of 10 linear feet of the nearest portion of a fence on seller's property, the 3 feet of the residence or garage. If there is evidence of present infestation as described above, or if damage caused by present or prior infestation is discovered, seller at seller's expense shall repair any damage caused by present present or prior infestation and have the present infestation treated by a licensed pest control company. If the cost of treatment and repair of such damage exceeds 2% of the purchase price, seller may, at seller's option, cancel this contract unless buyer, at buyer's option, should choose to pay for the cost of treatment and repairs exceeding 2% of the purchase price. Then this contract shall remain in full force and effect. If such report reveals damage for which the cost of treatment and repair exceeds 2% of the purchase price, seller's decision regarding treatment and repair of damage shall be communicated in writing to buyer within 5 days from receipt of the report, after which buyer shall respond to seller in writing with buyer's decision within 3 days from receipt of seller's notification of seller's decision. If seller does not notify buyer in writing of seller's decision within 5 days from receipt of report, buyer may, at buyer's option, pay for the cost of treatment and repairs exceeding 2% of the purchase price. If buyer does not want to pay for the cost of treatment and repairs exceeding 2% of the purchase price, buyer may terminate this contract upon written notice delivered to seller. In the event this contract is terminated under the terms of this paragraph, the deposits shall be dispersed in accordance with the deposit paragraph of this contract.
What does all that mean?
Somebody made a lot of money.
That means you can get your money back.
Terminates is a reason to void the contract.
So does a seller have to make repairs and treat for termites?
Not necessarily.
No,
Unless buyer pay for it.
no, the seller doesn't have to. What if it only costs 1%, does the seller have to? No, the seller can still decline. But if the cost exceeds 2%, the seller needs to declare the contract null and void, or he needs to tell the buyer within 5 days of receiving the report, that he's not making the repairs. What if the seller doesn't say to the buyer that he's not fixing it within 5 days?
He's gonna be on the hook, right? Is he gonna be obligated? No.
No, because now it's in the buyer's hands. Does the buyer want to pay that 2%? Does he want to pay over the 2%? What's the buyer have to do?
Provide written notice that he's terminated.
That's correct. How many days does he have to do that? Nope,
3.
3.
Now, if the contract becomes void, the seller, if he attempts to sell this property again, has to disclose that property terminates.
If the seller decides not to sell the property because of that,
He doesn't.
and he wants to put it back on the market, it's the agent's responsibility to inform everybody of a material fact that the property has termites.
His agent. the
His
seller's
agent's
agent.
responsible to disclose the material fact that
But
the
if he
property
waits
has
a
termites.
year and uses a different agent,
The agent that had the listing at that time has a responsibility to disclose the material fact.
Wait a minute, but what she's saying, if it's the year later,
If it's a year later, the agent that had it listed before has a responsibility to disclose that it is a material fact that the property had over 2% worth of damage.
to
And
the
they did
new
not,
agent.
yeah. And to anybody that wants to write an offer on it.
Well, how will that agent know? I mean, you had the listing and now it's a year later, you don't have it.
And if it comes up on the market,
You have to just watch that your
And
stuff doesn't. come
you,
up.
when it comes up, you call. Yeah, see, you listed this property, does it still have termites? No, they never said anything about termites. Well, I'm telling you right now that we had an inspection done a year ago and it had termites and it had termite damage. It is your responsibility to disclose material defect. It's like if you know for a fact that a basement gets water, you've got to tell somebody, I know the basement gets water.
And if the person who bought it discovers that, whenever they discover it, they can still bring that up. in
They can
litigation.
still bring that up into court 3 years from the date of discovery.
That's interesting.
The deposit, if the deposit is held by a broker as specified in paragraph 7C of this contract, buyer hereby authorizes and directs the broker to hold the deposit instrument without negotiation of deposit until the parties have executed and accepted this contract. Upon acceptance, the initial deposit and additional deposits, if any, shall be placed in an escrow as provided in paragraph 7E of this contract in accordance with the requirements of section 17502B1 of the Business, Occupations, and Professions Article Annotated Code of Maryland. If the seller does not execute and accept this contract, the initial deposit instrument shall be promptly returned to the buyer. The deposit shall be dispersed at settlement in the event this contract shall be terminated or settlement does not occur. The buyer and seller agree that the deposit shall be dispersed by the broker only in accordance with a release of deposit agreement executed by the buyer and seller. In the event buyer and seller fail to complete the real estate transaction in accordance with the terms and conditions of this contract, and either buyer or seller to complete the buyer or seller shall be unable or unwilling to execute a release of deposit agreement, the buyer and seller shall hereby acknowledge and agree that the broker may distribute the deposit in accordance with the provisions of section 17505B of the Business, Occupation, and Professions Article Annotated Code of Maryland. So, if there's no mutual agreement, can the broker decide who gets that deposit?
That's where I read it.
Broker has to follow what?
The code.
The code. Code 17505B says there must be a mutual release of deposit. If there's not a mutual release of deposit, then the broker must give 30-day written notice to the person that claims they are due the deposit, who the broker determines should receive that deposit. You have to put together a letter and send it to both parties and both agents certified to determine who's going to get the deposit. If there's still no agreement on who's going to get the deposit, if they write back and say, no, you can't give the buyer back their money, the next step is you go to court. And then the court will decide who gets the deposit. If the contract has been terminated, it says for 1 year from the date of the contract, you would go to mediation. So if the contract's been terminated, are you going to go to mediation over a dispute in the deposit if it was terminated? No. You're not. You're going to go to court.
Why do you go?
Because the court determines who gets the money. Yep.
Is it really worth it though? And then what?
Usually it's not.
So the money then sits.
Because
in
it
your
costs
account.
$700 to go to court.
Yeah, what's your,
So if it was only a $500 deposit, what should you do?
so then that money sits in your account for.
I don't know how long it sits there.
just
We
sits there.
got a couple of them that are just sitting there.
You never really had a mediation. It took about a year to resolve. Even
Yeah.
once they had started mediation, it's not a quick process.
Well, that wasn't actually mediation. That was
getting it all up to mediation and all of that. It wasn't resolved for a while.
It wasn't, yeah, it wasn't. And then when everybody showed up at court, they said, okay, go and give it back. Because then it got real. Deed and title. Upon payment of the purchase price and deed, oh, wait a minute. Who do we have online? Let's go to Susie Butt. Read paragraph 21.
Trying to read it from my phone, so I can hardly see it.
Oh,
Hold on. Upon payment of the purchase price, a deed for the property containing covenants of special warranty and further assurances, except in the case of transfer by personal representative of an estate, shall be executed by seller and shall convey the property to the buyer. Title to the property, including all chattels included in the purchase, shall be good. I need better glasses, and merchantable, free of liens and encumbrances except as specified herein, except for use and occupancy restrictions of public record, which are generally applicable to properties in the immediate neighborhood or the subdivision in which the property is located, and publicly recorded easements for public utilities and any other easements which may be observed by an inspection of the property. Buyer expressly assumes the risk that restrictive covenants, zoning laws, or other recorded documents may restrict or prohibit the use of the property for the purpose intended by the buyer. In the event seller is unable to give good and merchantable title or such as can be insured by the Maryland licensed title insurer, with buyer paying not more than the standard rate as filed with the Maryland Insurance Commissioner, seller at seller's expense shall have the option of curing any defect so as to enable seller to give good and merchantable title. Or if buyer is willing to accept the title without said defect being cured, paying any special premium on behalf of buyer and to obtain title insurance on the property to the benefit of buyer. In the event seller elects to cure any defects in title, this contract shall continue to remain in full force and effect, and the date of settlement shall be extended for a period not to exceed 14 additional days. If the seller is unable to cure such title defects and is unable to obtain a policy of title insurance on the property to the benefit of buyer from a Maryland licensed title insurer, buyer shall have the option of taking such title as seller can give or terminating this contract and being reimbursed by seller for cost of searching title as may have been incurred not to exceed 0.5% of the purchase price. In the latter event, there shall be no further liability or obligation on either of the parties hereunto, and this contract shall become null and void, and all deposits shall be dispersed in accordance with the deposit paragraph of this contract. In no event shall the broker or their agents have any liability for any defect in the seller's title.
so what does that paragraph mean? That's a lot of stuff, right? Basically, the seller has to provide clear and free title. The only time the seller usually cannot provide clear and free title is if they owe more than the property is worth, or if there's cloud on the title. Cloud on the title company is going to find that information out. They're going to be in touch with you as a buyer's agent to let you know what's going on. They do have 14 days to get it cleared. It's going to take longer than 14 days to clear some clouds on title. So you can declare the contract null and void, deposits would be given back to a buyer, and then they can come back later and purchase the property. If the buyer wants to continue, because the title company says they'll still issue title insurance, I probably want an attorney to look into that a little bit more.
Can the seller definitely get that 14 days without the buyer walking?
It says that they have 14 days to clear.
So they
it.
can clear it
They
within
can.
14 days and not have, if the buyer decides to walk before we get a 14-day chance, can we get the earnest money deposit?
It says it automatically extends for 14 days.
So then if they walk, we would get it back.
Now, wouldn't it be kind of suspicious, I mean, for a title, but, you know, why would a title company go ahead and issue insurance if there's something?
That's not for me to answer. That's for an attorney to answer. I would seek competent legal advice if a title company is telling me there's cloud on the title, the seller is willing to still sell it, and you as the buyer, you're willing to still buy it without that being cleared up. I would seek competent legal advice if the title company is saying, "Ah, don't worry about it." Ha, I like that face.
Because doesn't that technically make the buyer liable for the?
Sure does.
Well, chances are good they won't be able to issue title insurance on it, right? So it won't close anyway, unless it's cash.
Well, not necessarily, because the property that I was in the process of purchasing in Berkeley Springs, we found cloud on the title. The cloud was, the builder built this house by going up and saying, actually, it wasn't a cloud, but it came back. So build this house right here. No survey, no nothing. So start building the house right here. I think this view is just wonderful. Somebody's gonna buy this house. Several people bought that house. We come along and I'm like, I say to my buyer, we should have a house location survey done. Just to make sure, because if there's something that comes up later, your title insurance won't cover it. And they said, oh, it's a good idea. We did. The person that purchased it before also had title insurance. His title insurance was not responsible for clearing the issue because he didn't do a house location survey. He had to clear to get it sold. We gave him the time that he needed because he ended up going back to the developer. And the developer said, oh God, yeah, we did make a mistake. That whole neighborhood, all the houses were built with 50% of the house being on the other person's property.
Oh, and they didn't realize that? I mean, when they're drawing their little.
Hey, when the builder looks at the guy that's digging the hole and says, start building it right here, it looks good.
There's your son. They have to abide by like setbacks too, right, from the street.
Sure did. All the setbacks were just perfect,
No, because I know.
with the
there's a
exception of the
house
one that was where all of them, the property line went right through the center of the house.
But, you know, I always see, if you go to look at new houses or anything, you see these neat little things that developers have on the wall, all the little plots and everything. They just do that.
Those are all engineered. And this particular person, they had those engineered. And when it was all said and done and we got everything cleared, lo and behold, none of the lots look like that anymore. Because they screwed up. They screwed up with the first house, and then they went on to the second one, and then went on to the third one, the fourth one, the fifth one. I think there was a total of like 12 to 14 houses in that development. It's just a small development. Every single one of them was wrong.
What they end up doing.
Well, the developer had to come back into the picture and give land from somebody else. They had to pay for that land to get it from them and give it to us so that we had the appropriate amount of land with the appropriate amount of setbacks. And then they had to do that for each property after.
How long did that take?
Just for us to close, it took like an additional 45 days.
Oh, that's not bad compared to what I was thinking. I was thinking months and months.
It could have been a lot worse, but because it was Berkeley Springs, the developer actually sat on, and it actually sits on the zoning committee. I won't give any names.
No. Now I gotta go.
But he happens to be, and not just that, but he also happens to be a well-respected local politician in Berkeley Springs.
Everyone makes mistakes. Lenny, what contributes to the question?
I always tell my buyers to get a house location survey,
What's that, Ron?
about $200. The title company, I'm gonna tell you right now, the title company will say, well, you don't really need it. Especially in West Virginia, they'll say you don't really need it. No, you don't need it. But if you don't have it and you try to file a claim on your title insurance, guess what? You needed it.
Who conducts the house location survey? Where do you go to get it?
You ask the title company to have a surveyor conduct a house location survey. Buyer pays in closing. And I've even seen stuff, I even sold a property on Avon Avenue or Avon Road in Hagerstown, where the house actually had an issue where it was to be built on lot, and I'm gonna pull the numbers, just, it's supposed to be built on lot 17 and 19. 18 was sold to somebody else. And lot 17, 18, and 19 were in a row. House location survey will save money eventually at some point, possibly. Could be a waste of one too.
Can that also be used then, like if you wanted to have a fence or something?
No, a house location survey only gives you general idea of where the distances are. If you want to put up a fence, you actually have to have a survey where they measure it out and do the pins. Because there's many homes out there that the fence goes up because, well, they mowed the grass right along there.
So what if you just tell your buyer to get a house survey?
House location survey?
Instead of the house location, get the other one, sounds like the other one's more.
Yeah, you don't want to do that.
But it's like an issue this year, right? It's like $1,000.
So here's the thing, a house location survey is $200. That makes sure that the house and any fences or any sheds are within the boundary of the property and they abide by the setbacks. What you're talking about doing is gonna cost about $1,500 to do a boundary line survey. And depending on how big the property is, it goes up from there. You're gonna survey, the survey that was done on that particular property, because there was 15 acres involved, which is why they just said, you know, build it here. The actual boundary survey, when they had to pay for the new boundary survey, to add land to it, like $18,000.
Now, so if you have a survey done on your property, then you sell your property, is it like good? Do you hand that off to the buyer? Do
You can if you want to, but you're the one that paid $1,500 for it, or whatever you might have paid for it.
But once you lose the property, I mean, you don't need it, right?
No, once you leave the property, you don't need it.
If you can always sell it back to. You probably have to go back to the surveyor on that, 'cause it's their
Yeah.
report.
Because the surveyor does the report on it.
So the title insurance is only covering who owned it and did they have clear title?
Title insurance just ensures that there's clear title. But nobody can come back on the property and say that I owned it and it wasn't supposed to be sold, things like that. Or situations where had he had a house location survey done the title insurance would have had to pay to get that issue cleared up. They would have had to pay the $18,000 for the survey. They would have had to pay for the land to be butted up to it from the other person versus the guy selling the house. The guy selling the house ended up having to pay for all that out of pocket because he didn't have. And then afterwards, he decided he was going to take the developer to court because he no longer made any money from the house.
Did you win? I assuming you won.
I think he and the developer settled out of court. I don't think the developer wanted to go to court. So the essence of that paragraph is the seller has to provide clear and free title to a buyer. If they can't provide clear and free title, they've got 14 days to do so. Otherwise, all parties can then declare the contract null. Paragraph 22, the condition of the property in possession. This is one of my favorite ones. This paragraph basically states that the property must be left in the same condition or better, room clean at the time of possession, unless it's being sold as is, at which time it must be room clean and free of all trash and debris. Room clean means many different things to many different people. And if the only broom they had was the whisk broom that they kept in the back of the car that only had 3 bristles left on it, that's what he got cleaned with. Okay? So, 23, adjustments. Who wants to take this one?
Adjustments. Ground rent, homeowners association fee, rent and water rent shall be adjusted in portion as of date of settlement in all taxes, general or special. And all the public government charges, assessments against the property, which are may be payable in periodical basis, including Metropolitan District Sanitary Commission, Washington Suburban Sanitary Commission, or other benefits charge assessments, liens or encumbrances for sewer, water, drainage, pavement, or other public improvements completed or commenced on or prior to the date hereof, or subsequent thereof, as to be adjusted in a portion as of the date and settlement or to be assumed and paid therefore by the buyer. Whether assessed have been levied or not as the date settlement, if applicable by law, local law, any carrying or cooking fuels, heating or cooking fuels remaining in supply tanks at the time of settlement shall become property of the buyer.
So what's that paragraph say?
That last piece is new.
Yes. Anybody want to give a good indication as to what that paragraph means?
Some things are settled at the settlement table.
What that paragraph means is all the property taxes, water and sewer fees are all going to be prorated. The seller is going to be escrowed for water and sewer, probably up to $300. Property taxes are going to be prorated. The buyer is going to pay the seller back for any property taxes they have already paid. The buyer is also going to pay property taxes forward of that time frame. And all those adjustments will be made on the final alta, which is part of their closing costs. That also means transfer and recordation taxes. Settlement costs. The buyer agrees to pay all settlement costs and charges, including but not limited to all vendors' fees in connection herewith, including title examination, title insurance fees, loan insurance premiums, all document prep and recording fees, notary fees, survey fees, where required, and all recording charges except those incident to clearing existing encumbrances or title defects. except if the buyer is a veteran obtaining VA financing. Those prohibited to be paid by a veteran obtaining VA financing, which prohibited charges shall be paid by the seller. If a buyer is a veteran obtaining VA financing, buyer's broker may not charge a flat fee to the buyer nor to the seller per VA regulation, part 38, CFR 36, 4313B.
Question.
So what does that mean?
That last piece, so if the person is a veteran and is getting a VA loan to buy something, you can't, when you do the buyer agreement with them, you can't charge them that flat $295.
That's correct. You also can't charge the seller.
You can't charge the seller. Okay, so what if you already did? I mean, if it was Pennsylvania, does this apply in Pennsylvania?
Well, you see where it says part 38 CFR?
Yeah.
That's a congressional federal regulation.
What do you do at this point?
If you got away with it.
Yeah,
Usually
they
the
usually
title
take
company,
those.
usually the title company will say it's got to come off. The buyer has to pay all those settlement costs unless you ask the seller to do so. There's a separate addendum for that. Transfer charges. Transfer charges in general, section 14104B of the Real Property Article Annotated Code of Maryland provides that unless otherwise negotiated in the contract or provided by state or local law, the cost of any recordation tax or any state or local transfer tax shall be shared equally between the buyer and seller. So what does that mean? It means all state transfer and recordation taxes are going to be split 50-50. B, if they are a first-time home buyer, under section 14104C of the Real Property Article, the entire amount of the recordation and local transfer tax shall be paid by the seller of the property that is sold to a first-time Maryland home buyer unless there's an express agreement that the recordation tax or any state or local transfer tax will not be paid entirely by the seller. Recordation and local transfer tax, if the buyer is a first-time Maryland home buyer, buyer and seller expressly agree in accordance with section 14104C of the Real Property Article Annotated Code of Maryland that payment of the recordation tax and local transfer tax shall be shared equally between the buyer and the seller unless a first-time Maryland home buyer transfer and recordation tax addendum is attached, which contains a different express agreement. Any questions with that?
Just explain briefly.
Huh?
If you could just explain like. paraphrase.
Well, if you go further down, read the state transfer tax. Under section 13203B of the Tax Property Article Annotated Code of Maryland, the amount of the state transfer tax due on the sale of a property to a first-time Maryland home buyer is reduced from 0.5% to 0.25% and shall be paid entirely by the seller. The buyer is hereby notified that to ensure the receipt of the above reduction, buyer should so indicate on page 10 of this contract and complete the required affidavit at settlement indicating that the buyer is a first-time Maryland home buyer. So if the person is a Maryland first-time home buyer, the transfer and recordation taxes are always split 50-50. If they're a first-time Maryland buyer and they want the transfer and recordation taxes to be paid solely by the seller, you need to use the first-time Maryland home buyer addendum.
check this.
You'll also check that, but yeah, but you need the addendum. If you're asking the seller to pay it all. If the buyer is saying that they're going to pay it all, you'll need to have the first time Maryland home buyer addendum. What you most commonly see is the agents will fill out the Maryland first time home buyer addendum and write in the bottom that they split it 50-50. You don't need the addendum if it's being split 50-50 like it says in the contract.
You only need the addendum if you want the seller
To pay it all, or if the buyer is going to pay it all. If it's being split 50-50, you don't need the addendum. You just do the checkbox and move on.
If it's doing 50-50, the first time home buyer is getting it for the 0.25, they're not the 0.5.
The seller is paying a 1/4%, because the only tax that they are exempt from is the state recordation tax, which is 0.5%. And it will be reduced to a 1/4%, because 50-50 would have been a 1/4% to the buyer, 1/4% to the seller. Only a 1/4% is going to be collected from the seller because they're splitting it 50-50, and the first time home buyer is exempt.
Now, who does all the math? Is it the lender or who is?
Title company.
Is it title?
But you need to verify it on the Alta that he's not paying the state recordation tax as a first time home buyer. And it'll stay on the first on there.
Not on the closing. On the closing cost thing.
On the closing document, the final Alta.
The settlement.
So they're paying the 50%, the seller's paying 50% plus the 0.25%.
No,
on the other
they're only
side.
paying a 1/4%.
Getting this.
I always thought
Don't know.
that the buyer's
You
portion.
should.
Because it's 50-50,
It's always 50-50.
right? But then
However,
if he's
If-
paying $50 and he's paying $50, now this guy's a first time home buyer.
So he's exempt. So he
Right.
pays 0.
He pays 0, the seller has to pay for the extra.
No, he's only going to pay a 1/4%.
So he's
The
paying for his
the
50
whole,
plus a
the
1/4%.
whole state transfer tax is 0.5%. 0.50%.
If it's not a home, first time home buyer.
If it's not a first time home buyer, that's going to be split 50-50 between the buyer and seller.
Correct.
If he is a first time home buyer, it's still split 50-50. But the buyer is exempt from paying it, and only the seller is
So
going
it
to pay a
pays their
1/4%.
so the
That's
state
it.
is
Yeah.
taking.
Okay,
the state's
Basically,
taking
Yeah, I thought they were
the buyer's
taking his
portion
and
is
putting on theirs.
waived off.
The buyer's
That's
portion
basically
is
what
waived,
it's
and that's
Yeah,
it.
that's
And
it.
no
Yeah,
one
okay,
else,
I get it.
it's being absorbed by the state, not by the.
I thought I've been saying it wrong the whole time.
No.
Like, oh, okay.
That's how I understood
But-
it, but every time he explains it, it makes it sound like they're,
It had me
because it
confused
says
too.
here, even the seller is paying it. It says in this paragraph,
That
That's
he's
why it's
paying a
confusing.
1/4%.
right, but
It's
it's.
a
almost sounds like
0.5%.
he's Paying for the
He,
buyer's part, but he's not.
yes, he's only paying for the seller.
So it doesn't hurt you as a seller to go ahead and sign that because you're not getting any extra costs added to you.
Right.
So that's.
You
all
don't
need to
need, the only thing is, if you're not asking for it to be done differently than what it just said there, you don't need the addendum. The only time you need the first time home buyer addendum is if the seller is to pay all of it, or the buyer is choosing to pay all of it.
Why would either one of them do it?
Yeah.
First time.
I have
Negotiation,
had a seller agree to pay all of it for a veteran that was a first-time home buyer. Matter of fact, he was a disabled veteran. And rather than asking for a whole bunch of seller's assistance, we didn't ask for any seller assistance. We said, we want you to pay the transfer and recordation taxes, and that's all. And they agreed. So we did use that addendum. Broker liability. Brokers and their agents, sub-agents, and employees do not assume any responsibility for the condition of the property or for the performance of this contract by any or all parties hereto, By signing this contract, the buyer and seller acknowledge that they have not relied on any representations made by the brokers or any agents, subagents, or employees of the brokers, except those representations expressly set forth in this contract. What does that mean? That means you, as a real estate agent, didn't go out there and say, yep, the property line's right here. See where they mowed? And yeah, it's got a brand new panel box in there. So it looks like it doesn't mean it is. You make no representations. You let the professionals make the representations. Okay? The broker's fee. All parties irrevocably instruct the settlement officer to collect the fees of compensation and disperse the same according to the terms and conditions provided in the listing agreement and or agency representation agreement. Settlement shall not be a condition preceding to payment of compensation. What does that paragraph mean?
Even if you don't settle, the broker gets paid. Condition, like what the reason
What
is.
that means is, we did our work. We're gonna wait until closing to be paid. And if it doesn't close, you do still owe us money because we deserve to be paid. Do we do that? Most times, no. Who wants to be the guy that goes after the poor buyers, didn't have any money to begin with, pay a buyer's fee because he didn't close?
Depends on how much you like them or not.
So do you tell them?
Who wants to go after the seller that decided they weren't gonna pay the commission just because they weren't gonna pay?
So do you tell your buyer that?
No,
No, it just depends on how much you like them or not. You don't want to tell them that up front.
because you are due compensation. And one of the, I hear this question all the time. Well, they really can't afford to buy a house right now. So I'm willing to just go do the paperwork for them. Can I not charge them? Are you in the business of doing charity? I mean, if you work, are you a charity? Are you doing this for
Are you
charity?
talking about the $195 flat fee? Is that-
I'm talking about even the commission.
Oh, even the commission, oh. Oh, yeah, is the commission negotiable in regards to like listing at home? Is it a flat fee?
A commission is negotiable to a certain point. But a commission is not negotiable to zero. Office policy says we will charge 5% for a listing. For a buyer, we will charge 2.5%. If you choose to accept less than that, you're still going to be charged at the 2.5 or whatever it is. So if you only brought 1%, then you got to make up the difference on that 1.5% that wasn't collected. We don't run a charity. When they go to work, they don't go to work for free for a day.
But we don't have to pay the flat fee if they pay it, the agent gets that. If they
No,
don't
there's a
pay it,
$195 fee that has to be paid to the office off of every transaction. Unless it's a VA transaction and the lender doesn't allow it. Out of that $195, if you decide not to collect it, that's on you. You're still going to be charged that $195.
and anything above $195.
If you're going to charge, and the thing is, whatever you're going to charge, you have to charge for everybody. You can't just charge $195 for this person, and then $295 for this person, and then $395 for that person. if you're gonna charge, like all of mine are charged at $295. And it doesn't matter, they're all charged at $295.
When you're dealing with new construction homes, you usually have a flat rate fee of like 2% or they give you an amount. How would that work?
Well, these are discussions that we've all been having lately because there's other real estate agencies out there that call themselves, I don't know how to get away with it. They call themselves 3% realtors. They only give 1.5%. Well, unfortunately, as a buyer, you know, you signed a buyer agency agreement that says you're gonna pay me 2.5%. They're gonna pay 1.5% of it. You're gonna need to pay me the other 1%. Just like when I had a for sale by owner before, I was working with the buyer. I charged 3% when I worked with the buyer. And the seller did not want to pay that 3% no matter what. So I went back to the buyer and I said, okay, I spoke with the seller. He's willing to sell you the house. He's willing to let me write up the offer. However, they're not going to pay my compensation. So if you want representation, you're either going to have to pay it or you're on your own. And he immediately, him and his wife looked at me, oh, no. We're not doing this on our own. We'll pay you. Okay. And they paid me.
Charge all you buy is 3%.
I do.
What if it's a buy and, you know, sell and buy?
If I have both sides of the transaction, I will reduce it. But I always charge a 6% commission.
When you say both sides, you're talking about dual agent or you're
I'm
talking
talking about the
you sell
listing
their
and
house
the
and then
buying.
you get the
I'm
house.
talking about the listing and
Okay,
buying.
right.
So in Maryland, you can't be a dual agent.
So
You
know
can
what?
still write an offer for a buyer. You just can't represent the buyer. And I'll reduce the commission by 1%. And the reason is we still have E&O insurance. And if somebody later on thinks that I did them wrong, they're still going to come after me. And I still got to pay into the E&O. And they're still going to drag me to court. And I still got to pay for a lawyer. Nothing's changed. It's all the same. So I'm going to charge as much as I need to charge to make sure that I'm covered. You know, when we're talking about compensation, there's a reason we get compensated what we get compensated. And a lot of people don't realize what that compensation entails. You know, insurance is one of them. The fact that they can still come back and sue you later for something maybe you said or you thought or whatever the case may be. They don't look at any of that. So you got to make sure you're charging them the right amount. Seller responsibility. The seller agrees to keep the existing mortgages free of default until settlement. All violation notices of requirements noted or issued by any governmental authority, including without limitation any permit violation notices or actions in any court on account thereof against or affecting the property at the date of settlement of this contract shall be complied with by the seller and the property conveyed free thereof. Property is to be held at the risk of the seller until legal title has passed or possession has been given to the buyer. If prior to the time legal title has passed or possession has been given to buyer, whichever shall occur first, all or a substantial part of the property is destroyed or damaged without fault of the buyer, then this contract at the option of the buyer upon written notice to the seller shall be null and void and of no further force and effect. And the deposit shall be dispersed in accordance with the deposit paragraph of this contract. So the seller has to keep their homeowner's insurance active. The seller has to keep the utilities on. The seller has to keep the grass mowed. The seller has to make sure that he's still maintaining the property in the condition that it was in. If he gives the buyer possession prior to settlement, he still has to keep his homeowner's insurance on it. Because if he gives the buyer possession of the property, the buyer's not gonna be able to get homeowner's insurance on it until it becomes his. He can only get renter's insurance. So if he gives possession to the buyer and something happens and the house burns down, the buyer can walk away. That's what that paragraph says.
Would the seller's insurance cover it?
Mhm. Homeowners Association, or I'm sorry, buyer responsibility. If the buyer has misrepresented buyer's financial ability to consummate the purchase of the property, or if this contract is contingent upon the buyer securing a written commitment for financing, and the buyer fails to apply for such financing within the time period herein specified, or fails to pursue financing diligently and in good faith, or if the buyer makes any misrepresentations in any document relating to financing, or takes or fails to take any action which causes the buyer's disqualification for financing, and buying that furniture with no payments for 3 years, then the buyer shall be in default, and the seller may elect by written notice to the buyer to terminate the contract and or pursue the remedy set forth under the default paragraph of this contract. It also applies if the buyer provides non-sufficient fund deposit. Seller can declare the contract null and void, and the deposit would still be handed over to the seller. So if it's non-sufficient funds and the buyer just says, I don't care, I bounced my check, I'm not buying it. The seller still has a way to get that money. It's called the real estate guarantee fund. How do they get money from the real estate guarantee fund? They file a complaint against their real estate agent. Real estate agent, when that check bounced, that real estate agent is going to be turned in to the guarantee fund for not doing their job and doing their due diligence. So if the deposit is a $10,000 deposit, guarantee fund will find in favor of the seller. The agent will pay that $10,000 back to the guarantee fund along with a fine, I think somewhere around $2,500, before they can get their license back.
But nowadays, if you're doing this electronic transfer, wouldn't you know right away? I mean, he has to transfer $10,000 to go to transfer it. Guess what? There's no, you know.
That's what you said. It's earnest money.
I didn't say you wouldn't be held accountable.
What'd you say?
I said it's an electronic transfer. And the way it works is they'll look to see if the money's there, because they can only do wire transfers at certain times of the day. And if the money's there, they'll actually pay it if they can't get it. And then when they go in to get it, when they're allowed to get it, if it bounces or it's declared non-sufficient funds, it's gonna go back on you.
Well, and with earnest, so we realized that some people will move like $1,000 to an account and only write, their EMD out of that account. Take into consideration though, that earnest charges a $15 fee. So if all they have is $1,000, that's gonna bounce. They need to have $1,000 at 15 in there
$1,015.
for that to go through.
Both things are very risky.
Well, that's why in real estate school, they tell you real estate is risky. You can make really good money.
But
you have all the risk. You are the agent. You are the professional. And if you don't know what's in here, you're screwed. Which is why I always say, you've got to take these home and read them. And trust me, I know by looking on how the contracts are filled out if they were taken home and read.
At what point do you see the contract after we like pull them out from the DocuSign?
Once you have a ratified contract and it is submitted for compliance, that's when I will see it.
So like if my buyer's offer was accepted and we have it back from the listing agent, that's what we upload into DocuSign.
That's what you upload into DocuSign
Into command. That's
Or into
what we upload
command.
Oh.
so that I can go through and do compliance on it.
What is the errors and omissions actually covering? I mean, so it's not covering if you're responsible to pay.
Well, your errors and omissions insurance, if you made a true error, the errors and omissions insurance will cover certain instances. However, the only time that they cover is if you were not negligent in doing your job. So that leaves open, that's open for a broad spectrum.
Yeah, because how would you know if the person has the money in the bank? How would we know that? We has to see proof of funds, that they could spend it.
Most times, we as agents take it on good faith. Until we get notice that, I checked that. Most times, when you contact the buyer and they say that, they are immediately trying to rectify it.
So only if they walk away do you have.
If they don't rectify it, you're gonna be the one held responsible to rectify it.
And I always let them know that this will be getting cashed.
Yeah.
Make sure that they know.
Yeah.
That it's not something we're just gonna hold on to for.
Homeowners Association, the property is not part of a development subject to the imposition of mandatory fees as defined by the Maryland Homeowners Association Act unless acknowledged by the attached addendum. So if there's no HOA, you don't have to attach any addendum. If there's an HOA, you gotta attach an addendum.
What happens if you don't, and then the person finds out there is?
They can declare the contract null and void. And you could end up costing them their money if you didn't find out in time and manner. Ground rent, if the property is subject to ground rent and the ground rent is not timely paid, the ground lease holder, the person to whom the ground rent is payable, may bring an action under section 8402.3 of the Real Property Article Annotated Code of Maryland. As a result of this action, a lien may be placed upon the property. If the property is subject to ground rent, section 14 through 116 and 14.116.1 of the Real Property Article provide the purchaser upon obtaining ownership of the property with certain rights and responsibilities relative to the ground rent. If the property is subject to ground rent, see the property is subject to ground rent addendum. Like I said, Washington County, you don't have to worry about ground rent. Lot rent and ground rent are two different things. Ground rent, you're going to see in Baltimore and Howard County and down in that area. What ground rent, what ground rent? Somebody on my foot. Ground rent was actually established by builders many years ago because they didn't have loan programs where people could put 3.5% down or no money down to purchase property. So the builders got together and said, we have to come up with a way to be able to recoup costs of selling these people homes that don't have 20% put down. And this is how they did it with ground rent. Now Maryland is trying to do away with the ground rents slowly and surely, and they will. Because as the transfers are taking place, they're eliminating them because they said the ground rent's been paid many times over from what was actually owed. So they are doing away with it. And I don't know if ground rent's a big thing in other areas. but it was in Baltimore and Howard County. Sale, settlement, or lease of other real estate. This is an important paragraph. Because it states that neither this contract nor the granting of the buyer's loan referred to herein is to be conditioned or contingent in any manner upon the sale, settlement, and or lease of any other real estate unless a contingency for the sale, settlement, and or lease of other real estate is contained in an addendum to this contract. Unless this contract is expressly contingent upon the sale, settlement, and or lease of any other real estate, the buyer shall neither apply for nor accept a financing loan commitment which is contingent upon or requires as a precondition to funding that any other real estate be sold, settled, or leased. What does that mean?
If they have two properties they own that are.
I'll give it to you. What this paragraph means is buyer purchasing it is not, does not have to sell another piece of property. The seller selling it doesn't have a contingency to purchase another property. So if you don't have a contingency for a house to settle or for a home of choice, what happens if their closing comes and the seller hasn't found a home? That's right, they're homeless. They have to move out.
Well, in the case we just had, couldn't they rent until they find their new property?
Depends on whether or not the new owner wants to let them rent.
So that is an option though.
Yeah, we rented for 2 weeks only because suddenly the woman was expecting. So they gave us 2 weeks and then we moved into a hotel.
So it's not contingent on any other property selling. So unless you put those contingencies in the contract, you can find yourself, especially if you're working with a seller that needs to find a home of choice, in a lot of trouble.
What number is that?
It's not, that's number 32.
Oh, and something that I found out, working with VA buyers, the seller wanted to do a post occupancy. A VA loan, I don't know about FHA or any others, only allowed a 30-day
Yep.
post op. So just remember that and make sure you ask your buyer's lender, hey, seller's asking for a post occupancy, how far out are they allowed to, to grant or whatever, if the buyers are okay with it. VA, they had to be in there within 30 days of settlement.
Leases. The seller neither negotiates new leases nor renew existing leases for the property which extend beyond settlement or possession date without the buyer's written consent. What this means is that the property is being used as rental property. He cannot renew any leases. He cannot extend any leases. If the person's supposed to be out by the date of closing, they have to be out by the date of closing. If the buyer is going to be using it as a rental property also, the buyer has the right to determine if a lease can be extended or not. Default, the buyer and seller are required to make and agree to make full settlement in accordance with the terms of the contract, and acknowledge that failure to do so constitutes a breach hereof. If the buyer fails to make full settlement or is in default due to the buyer's failure to comply with the terms, covenants, and conditions of this contract, the initial deposit and additional deposits may be retained by the seller as long as the release of deposit agreement is signed and executed by all parties, expressing that said deposit may be retained by seller. In the event parties do not agree to execute a release of deposit agreement, the buyer and seller shall have all legal and equitable remedies. If the seller fails to make full settlement or is in default due to the seller's failure to comply with the terms, covenants, and conditions of this contract, the buyer shall be entitled to pursue such rights and remedies as may be available at law or in equity, including without limitation, an action for specific performance of this contract and or monetary damages. Everyone with me so far? In the event of any litigation or dispute between the buyer and seller concerning the release of the deposit, the broker's sole responsibility may be met at broker's option by paying the deposit into the court in which such litigation is pending, or by paying the deposit into the court of proper jurisdiction by an action of interpleader. The buyer and seller agree that upon the broker's payment of the deposit into the court, neither the buyer nor the seller shall have any further right, claim, demand, or action against the broker regarding the release of the deposit. And the buyer and seller jointly and severally shall indemnify and hold the broker harmless from any and all such rights, claims, demands, or action. In the event of such dispute and election by broker to file an action of interpleader, as herein provided, the buyer and seller further agree and hereby expressly and irrevocably authorize broker to deduct from the deposit all costs incurred by the broker in the filing and maintenance of such action of interpleader, including but not limited to the filing fees, court costs, service of process fees, and attorney's fees, provided that the amount deducted shall not exceed the lesser of $500 or the amount of the deposit held by the broker. All such fees and costs authorized herein to be deducted may be deducted by the broker from the deposit prior to paying the balance of the deposit to the court. Buyer and seller further agree and expressly declare that all such fees and costs so deducted shall be the exclusive property of the broker. And the amount deducted by the broker is less than the total of all the costs incurred by the broker in filing and maintaining the interpleader action, then the buyer and seller jointly and severally agree to reimburse the broker for all such excess costs upon the conclusion of the interpleader action. Sounds like a lot, doesn't it? Basically, the buyer and seller are going to be responsible for the interpleader. If it goes to interpleader, it's going to come out of the deposit, and any remainder will go to the person that is entitled to go to. So if the deposit is $1,000, the brokerage is going to hold probably roughly $700, give the $300 to the court, and then whoever is entitled to the $1,000 is going to receive that $300.
Interpleader, like a mediator?
An interpleader is where the judge determines who gets the deposit. There is no mediation for a deposit. Mediation of disputes. If a dispute were to arise, we're going a little bit long here. I want to answer questions for people, so I'm going to try and trying to push this along. Okay. So mediation of disputes. From the time of closing for up to 1 year after, all parties agree to go to mediation if there's anything that's wrong. So the buyer cannot immediately take the seller to court until after 1 year has gone by. You have to go to mediation. Mediation costs $700. It's going to cost each party $700. And then they're going to come up with an agreement, and you're going to abide by the agreement. If you choose not to go to mediation and you choose to do litigation, instead, you're going to have to wait that full year, go to litigation, and whatever happens in the litigation, you're going to be responsible for the attorney's fees, and whoever is found at fault is going to be responsible for all of it. That's what the next paragraph says. Settlement service providers. The buyer has the right to choose what settlement company they want to use. A lot of times what will happen in short sales is they will recommend a settlement company because the settlement company is helping do negotiations in a contract for a short sale. But the buyer has the right to choose who they're gonna use. A lot of times you'll see in foreclosures that they want you to use a specific title company. They won't pay seller's assistance if you don't use that settlement company. But the buyer does have the right to choose. Property owner's title insurance. The buyer at the buyer's expense may purchase the owner's title insurance at either standard or enhanced coverage rates. So this paragraph basically alludes to the fact that a buyer can use a seller's current title insurance to be given a reissue rate on title insurance for his loan. Okay. If you want to help your buyer with a little bit of money, it's a couple $100, you can ask that the seller provide title insurance to use on behalf of the buyer. Authorization to provide TILA RESPA. What's TILA RESPA?
Truth in lending statement
Truth in Lending
Act.
Act.
and the real estate practice.
Real Estate Settlements and Procedures Act. So this is why we have to use a disclosure, a business affiliated disclosure, if we're using Keller Mortgage, or if we're using another company that we're affiliated with. We have to let them know that we're affiliated with them, we earn money from them. Title companies have to do the same thing, and other lenders do as well. Limited warranties. Notice to a buyer that a warranty plan can be purchased at closing to cover items in the home if they so choose to. There's no guarantee that they're going to cover those items. There is a property insurance brochure that you can download from the Maryland Association of Realtors website, that you should give to potential buyers to familiarize themselves with homeowners insurance. First-time home buyers don't know they have to get homeowners insurance. You have to include them in on that. Flood disclosure. If the property is located in a floodplain, you have to disclose that it's in a floodplain. The buyer has to do their due diligence and find out what that insurance is going to cost them. And there's several different places that they can go to find this out. They can go to the FEMA website to find out if it's in a floodplain, and then there's another website that they can go to determine what the cost of flood insurance is going to be. They are both listed. Here's the guarantee fund. If the buyer is protected by the real estate guarantee fund under the real estate commission, business and occupations and professional article of the annotated code of Maryland, for losses in an amount not to exceed $50,000 for any claim. So if they feel you misrepresented something, or if they had to spend an exorbitant amount of money to do something that wasn't normally, they can turn you into the guarantee fund, the real estate commission, and try to get that money back from the guarantee fund. If the real estate commission finds you at fault, then you will pay the guarantee fund back along with a fine before you get your license back. Single-family residential real property. There's only certain people that are exempt from doing a disclosure disclaimer. People that are exempt from doing a disclosure disclaimer are foreclosure, so bank, a sheriff's sale, tax, a power of attorney or guardian, if the property is condemned and they're going to be taking a bulldozer to it and nobody's allowed in it, or new construction. Those are the only 5 people exempt from doing a disclosure disclaimer statement. And no, your person would not be exempt because it has to be bulldozed.
So it's foreclosure, power of attorney, guardian, new construction. what was the other two?
If it's condemned or sheriff's sale. Tax sale. So does that mean somebody that's flipping properties has to do a disclosure disclaimer statement?
Yes.
That's right, they do. Do they? Usually they'll fill out the disclaimer and say no known defects. I got somebody that you can contact and talk to them all about that. She went to court over it. And when they asked him what he saw when they removed all the plaster and put up drywall, it was rather shocking because he saw it all. So you knew it. You knew there was knob and tube wiring. You knew there was galvanized pipe. You saw it. So be careful if you're working with an investor that's going to flip. Make sure that they're disclosing. You're going to go into court with them. Maryland non-resident seller. If they are a non-resident seller and they're selling property in Maryland, they're going to be. You need to notify them that they're going to pay 8.5% in property or in taxes. That's on their net. So if they're only making $50,000 from the purchase after all the deductions, that 8.5% is on that $50,000. Whatever they're going to make, that's what they're going to pay. At 8.5% on. The IRS is going to be notified that they sold the property and that the person buying it bought it. Chesapeake and Atlantic Coastal Bay critical area. We are not in that area because we're in Washington County. We have been declared not in that area, along with Allegheny, Frederick, Garrett, Howard, Montgomery, and Washington counties do not include and located in the critical area. However, there is exemption to that. The exemption to that is if you are along a body of water. So if you have a house and it happens to sit along the Antietam Creek, Conococheague Creek, or any other contributory to the Potomac River that goes into the Chesapeake Bay, you are in a critical area. Okay. Wetlands notice. Buyer has to be advised if the property is located in a wetland area. If any portion of the property is located in a wetland area, the buyer has to be notified. The Army Corps of Engineers has maps of places in Washington County that show you where there are wetlands. There are some houses on Morgan's Avenue that are in a wetlands area. You can't do anything with them because you can't destroy a wetland. That's why the buyer needs to know if it's going to be in a wetland. Forest Conservation Act, if the property is a tract of land 40,000 square feet or more in size, which is more than an acre, or a little bit less than an acre actually, 40,000 square feet in size. The buyer is notified that unless exempted by applicable law as a prerequisite to any subdivision plan or grading or sediment control permit for the property, the buyer will be required to comply with provisions of the Maryland Forest Conservation Act, which means they've got to put up that black material around the property when they're going to be building, or if they're going to be adding an addition on. They need to follow the Department of the Environment's regulation. So if your lot is 40,000 square feet or more, 40,000 square feet is just a little under an acre. It's like 0.8 something of an acre. Conservation easements, if the property is encumbered by a conservation easement, buyer has to know. There's documentation that you can apply for to keep it in a forest conservation easement, which you will want to do as a buyer because you get special tax incentives for that. Foreign investments, if they're a foreign investor and they're going to make $300,000 or more, they're gonna pay foreign investment taxes on the sale of the property
Only if they're going to make 300,000.
or more.
Yes. And what is the seller's taxes? Oh, they pay everything.
Criminal activity and sexual offenses. This paragraph states that there could be, the buyer is made aware of, that there could be sex offenders and criminal activity that goes on in that neighborhood. I, as a real estate agent, do not have a responsibility to tell you whether there is or is not. I, as a real estate agent, if I know for a fact that there is a sex offender that lives in a particular neighborhood, cannot disclose that. Because now you're infringing on somebody else's right. No,
I'm a little bit. You're not responsible for letting them know if they're
there's a website that they can go to.
live.
Tell them
If
that.
I
But if
know,
you-
if I know for a fact that there is a sex offender that lives at this house, I cannot tell
It's up to them to.
them. They have to find
So I
out for
can just
themselves.
tell them where they can find out.
Yeah, and that's what this paragraph said. That the buyer needs to do their due diligence and find out. And, you know, believe it or not, buyers are not dumb. Buyers get on the internet. They know this stuff, you know? They get on the internet and look. I mean, I've had buyers tell me, well, this isn't what they call a quiet neighborhood. Huh? First time I heard that, I was like, what? Well, I called the Hagerstown City Police Department and they claimed that this is not a quiet neighborhood. I said, what the hell does that mean? Well, they get a lot of police calls. Oh, I didn't know that. Because they asked me what I thought of the neighborhood. And I said, well, seems pretty good to me. I don't live here, but it seems
Drive
pretty
by
good.
at night.
Yes, right?
But you're not supposed to say that.
No, you're not supposed to.
Tell them, go to your local police station, check it out.
Well, yeah, you can tell, go to their website and find out. But buyers do that stuff ahead of time.
Right.
You know. Next paragraph doesn't apply, number 53, because it has to do with military installations. This section does not apply if it's in Allegheny, Carroll, Frederick, Garrett, Howard, Montgomery, and Washington counties. Do we have to tell them?
No.
Well, sure we do. We got to tell them what number 53 is.
Yeah.
That military that there could be military installations, but it doesn't apply in Washington County.
I don't think it applies perfect though.
Huh?
I don't think it applies perfect.
There's no airport there or anything like that.
Yes, it is.
It's a court district is.
So I guess David needs to conduct flight operations,
But they do
mission
something.
testings, or military operations.
Anything that has to conduct military installations, that's supposed to be top secret. We can't do that. Notice to the parties, no representations by the brokers or their agents. The agent didn't stand there and say, yep, there's the property line. I saw the guy mow. Cannot make representations to the property. That's drywall. Oh, that's plaster. That looks like knob and tube to me. I don't know. We'll have to check with an electrician. Because you cannot make any representations. You let the professionals do that. That includes surveyors and all that good stuff. Surveyors, contractors, all of it. Property tax notice. From the time that you purchase a property in Maryland, you have 60 days to appeal the property tax. There are forms that you can use to do so. There's also forms that a buyer can use to file for the homestead exemption. They will need to do that. You can provide those forms, or you can direct them to the website if you like. I will tell you that the last time I gave somebody the appeal to file an appeal on their property taxes, they got very angry. So I don't give it to them anymore.
It went up.
Because, and I told them that one of three things can happen if you file for the appeal, because one of three things is gonna happen. They're either gonna keep the property tax the same, unlikely. They're going to reduce the property tax, which is even more unlikely. Or they're going to say, oh, you're not paying enough property taxes, we have to increase it. And that's exactly what they said. I said, hey, I told you it could go one of three ways.
So you only mention it if they bring it up, otherwise you don't say it, right?
Well, I go over with them in the contract. And if they say, we're gonna find out, I tell them, well, there's three things that can happen. So which one do you want to gamble with? And most of the time they'll say, yeah, I took that.
And Maryland recognizes the homestead exemption?
It does if it's a primary residence. Only if it's a primary
Where
residence.
can you get the form?
That you can get off of the SSTAT site. Maryland Real Property Search SSTAT. This contract cannot be assigned to any other person other than the people that are involved in this contract. You might see somebody that scratches that out and initials it and wants somebody else to initial it. Be very weird. Computation of days as used in this contract and any addendum, the day count starts at midnight Eastern Time Zone. This is the entire agreement. Once signed, it is legally binding. If you don't understand anything that's in this, you should seek competent legal advice. Buyer says, I want to terminate it. Your advice to them should be, you should seek competent legal advice. Seller says, I want to terminate it. You should seek competent legal advice. Find out why first. Maybe you can help them realize that they need to go ahead and move forward. The buyer, now, there's addendums out there for the next two paragraphs. You don't need them. Paragraph 60 and 61 of the contract state specifically that you can conduct the transaction electronically using fax and email, and you can also use electronic signatures from other forms to proceed with the purchase and agreement of this contract. So when I see those other addendums included in the contract of sale, I would say, oh, look, somebody included the paragraph 60, 61 of the contract addendum. Once it's accepted, you need to fill in the date that the contract was accepted. Yeah, there's still initials needed when you're sending it back, you're not filling in that date. The other person. Information on page 11 is required and needed. Now we'll open everything up to questions. Everybody understand the contract itself?
So again, the date doesn't matter, like your writing offer is the day where you're writing the offer, right, or the contract. And if they sign the next day, it doesn't, they don't have to. This paper doesn't have to have the same date. Like, at the beginning,
The date of the offer is the date of the offer. The date of acceptance is the date that all parties have initialed and signed and agreed on all terms with all addendum. They're gonna be two different dates.
Okay.
Except for HUD, I think, that's a difference. I think, isn't it HUD that wants it all on one
HUD wants it all on one,
date?
so they won't, what you'll end up doing with HUD is you'll submit a whole bunch of documents, have your buyer sign them, you'll send them to HUD, and then HUD's gonna send back signed addendums by them that are blank, and your buyer's already signed all of them, but they don't want them. Yeah. So now's your time to ask me questions, because as of tomorrow, I'm on quarantine to make sure that I can have my surgery.
The first time home buyers, if it's husband, wife, one is it? Is that not applying in the first time?
That's right. If the husband already owned a home in Maryland and the husband and wife are buying a home, she's not eligible for the first time Maryland home buyer.
And then the day countdown, so like if I submit something today, 7 days starts tomorrow.
Correct. Is that all?
I have one quick question.
Go ahead.
This is confusing. Acting as intercompany agent with the broker as dual agent. So
Yeah.
dual agency is allowed in
No,
Maryland.
it's not.
Okay, so how are you?
Only a
acting?
broker can be a dual agent.
Okay, you can be. You can be. a
Read,
dual
read what that
agent.
said. Read
It
what it
says
said.
that I'm acting as intracompany.
Correct,
I'm not acting as dual agent,
correct.
Right.
So you may have a written buyer's agency agreement with the buyer,
right?
and I have the list.
Okay. I'm just wondering if I actually did this and they let it happen. I mean, this was not here. But I had one situation where. So,
Nope, you never did.
so then Coldwell Banker had the seller. They would have- I mean, the buyer.
Was it your listing?
Yes,
Okay, and the buyer contacted you.
Right.
And you wrote the contract for the buyer.
I did.
So you were representing the seller. The buyer was not represented.
Okay, all right, I got you. So I was getting nervous there. but I mean, done-
Technically, they don't have to.
They don't have.
They don't have to have representation,
All right.
but they are entitled to representation. And you do have to tell them that
And you
they are
have to give the
entitled to
written-
representation.
right,
And you have to have the
Written
written
consent.
understanding whom agents represent,
right.
disclosing that you are not representing them as a buyer, but you are representing the seller.
I have a lot of questions.
Okay.
For foreign buyers, what do I need to know? What do I need to find out from them? Or what do I need to tell
For
them?
a foreign buyer,
Yeah.
okay, so they're definitely gonna need the green card,
They don't have a green card and they're most likely paying cash.
doesn't matter. They're gonna have to have, then they have to go down to the Social Security Administration. But I've had this happen, where a foreign person bought a property for cash. They can do that. There's nothing that says they can't. Okay. But when they went to sell it, because the IRS, because it gets reported to the IRS, they have to have a green card or other documentation that shows that they can legally sell that property. So if they don't have a green card, they have to go down to the Social Security Administration, and there's a form that they have to get. And they'll get taxed.
So they are responsible for the tax.
Yeah.
When they sell the home.
Yeah.
So do I have to tell the other agent that the person is a family member of mine?
If they are an immediate family member of yours, yeah.
Like my aunt, for instance, or cousin. or so.
It's an immediate, if it's an immediate family member.
I would
Yeah,
family and
immediately
mother,
husband.
father, daughter, son.
Okay, so then I don't have to tell.
Like your mom, dad, grandparents, really.
I have a quick question. If a seller leaves stuff seller leaves stuff in the house, you're doing the walkthrough. They're charged 1.5 times, what number? I mean,
Well,
what's that based upon?
it depends on what's there
Okay,
and what it's gonna cost. I mean, I've walked into houses before where sellers signed off on everything early and left everything behind. And we had to request the $2,500 to be put in escrow because it was gonna cost at least $1,500 to get cleared out.
so it's based on, I mean,
Like an
Just
estimate from a
like
lawyer.
And it's gonna be
estimate
based on an estimate
Okay.
of somebody that's gonna clean it out.
yeah,
If
that's
you have a
all.
junk guy,
Okay. Okay, and,
and you always want 1.5 times, because if it doesn't cover the entire amount,
sure,
you know, I mean,
increase.
if the guy says it's only gonna cost $500 to get all this out, make it in there, it takes longer, and it actually costs $800.
So you're aware of a seller that left everything?
And I've seen a lot of stuff.
Yeah.
I've seen a lot, and because I used to have this, well, I still do. If it's gonna happen, it's gonna happen to me.
Not wrong.
What kind of documents do you need in command for new construction?
You're gonna put all the same documents in there. Contract, now they're gonna have their own contract. Most times with new construction, you're gonna put the whole contract in under the contract. And you're not gonna have some of the required documents in the places where they're supposed to be. Because a lot of times, with new construction, they'll have the financing contingency in there. They're gonna have, but what you're gonna have to do is you're gonna have to make a note. It's a place for you in the command to write notes, that this is a new construction. Okay?
So right now, I just have a ratified contract, I guess, right? And then I won't have any of the other papers on that.
Well, we probably won't have a lot of the other stuff in there, because it's all gonna be part of the contract. New construction contracts, and the thing is, when you're dealing with new construction with your client, it is absolutely a must that you read that contract with your buyer and go over it, because a lot of times, new construction contracts will have items in there like an appraisal waiver. Meaning the appraisal can come in $30,000 lower than what they're selling it for, and it doesn't matter. They're still obligated to buy it because they signed the contract and it's got an appraisal waiver. Dan Ryan is famous for that.
Lenny has a birthday next week and he's not gonna be here, so I thought we could celebrate while he's here. So we're just gonna sing happy birthday and then you guys can help yourself to some cake out here.
Had to tell me I'm getting a year older.
Ready?
Yep.
Happy birthday to you. Happy birthday to you. Happy birthday, dear Lenny. Happy birthday to you. And many more.
I was waiting on it. Thank you all very much.
Thank you. Okay,
Now, I know Nicole had a whole lot of questions. Yes, ma'am. Yeah.